Order. Questions for oral answer?
Mr. Speaker, sir, may I have your permission to address oral questions 1 to 19 as well as questions for written answers 19 to 23 in today's order paper through ministerial statements which will be delivered at tomorrow's sitting, sir.
Yes, I give my consent. That leads us on to question 20. Mr. Darrell David.
Mr. Speaker, on behalf of Minister Iswaran, can we seek your permission to address questions 20 and 21 in a ministerial statement to be delivered by Minister Iswaran later today, please?
I give my consent. That leads us on to question 22. Mr. Murali Pillai.
Sir, question 22, please.
Mr. Deputy Speaker, I will address the PQ from Mr. Murali Pillai to Cpib on behalf of the Prime Minister, please. Corruption is not tolerated in any form in Singapore. It undermines public trust and erodes our social fabric. Cpib does not compute the aggregate dollar value of corruption cases prosecuted, as corruption does not always involve money. It pursues all corruption cases regardless of the types of gratification, the quantum of contracts, or amount of bribes involved. Singapore has a hard-won international reputation as a country committed to the rule of law and zero tolerance for corruption. The strong political will to take firm action against all forms of corruptions and a society that abhors corruption have contributed to a clean and incorruptible Singapore. Businesses have the confidence that their investment can thrive here because our rules are transparent and applied fairly. Singaporeans can fulfill their potential through their own efforts and hard work in our meritocratic society. Corrupt offenders bear the full brunt of the law and face severe punishments. In addition, Cpib spares no effort to disgorge criminal gains and unexplained assets of those convicted of corruption offences through its rigorous asset recovery efforts. In 2018, 2019 and 2020, the total value of forfeitures imposed by the courts for Cpib cases were about 2.4 million, 3.8 million and 2.2 million respectively. The pandemic underscored the importance of digital transformation as some of Cpib's initiatives on this front had minimized disruption to its operations and service delivery. Some examples include the electronic reporting of corruption complaints and the electronic bail platform, which provides bailers and bailees with safe and convenient access to bail extension services virtually. Cpib also launched a digital investigation paper project where documents can be digitally and securely prepared, transmitted and accessed. Cpib will continue to take bold steps to transform itself and develop its operational readiness to meet emerging challenges in a post-COVID-19 future. To stay ahead of the curve, Cpib has invested in state-of-the-art digital infrastructure through collaboration with strategic partners such as the Home Team, Science and Technology Agency, and other agencies. Some examples include the setting up of a new command center that enhances situation awareness and the upgrading of digital forensic analytic capabilities. In the prevention and outreach arena, Cpib has co-created public education resources with students from institutes of higher learning such as Nanyang Polytechnic and schools such as St. Joseph's Institution. Some initiatives include an e-book on actual corruption cases and its consequences on the society, and a game web application incorporating anti-corruption materials for young adults. Singapore's clean and corruption-free reputation should not be taken for granted, as it is not immune to the virus of corruption. Singapore must keep fighting corruption wherever it exists and in whatever form it takes. There is no room for complacency, and it requires the constant vigilance and resolute determination of the government, the public service, and the community to continue to keep corruption at bay.
Mr. Murali Pillai.
Mr. Deputy Speaker, sir, I thank the Honourable Minister for his comprehensive answer to my parliamentary question. Honourable members would have also read the CPIB's Annual Report 2020, which was presented to Parliament on the 21st of April 2021. Sir, with your indulgence, please allow me to state that what CPIB has achieved last year and the preceding years with a lean team of just 200 people is commendable. The work to detect and investigate cases of corruption is complex. In most crime cases, there will be an identifiable victim, for example, a person who has been cheated of his monies or whose valuables have been stolen. For corruption, the paradigm is different. It's not a win-lose situation, it's a win-win situation involving the giver and the acceptor of bribes. As a result of its work, with the support of Singaporeans, Singapore has established a strong brand culture of being intolerant of corruption. Singapore and Singaporean businesses and Singaporeans enjoy a good reputation overseas for the same reason. For all this, we in this House owe the men and women of CPIB, past and present, a debt of gratitude. Sir, my supplemental question is twofold. As CPIB nears its 70th anniversary next year, what steps will it take to entrench the anti-corruption culture in Singapore, especially amongst our younger generations of Singaporeans who may not be as familiar with our past problems with corruption? Next, may I seek an update, if any, on the Honourable Minister's announcement made recently that the legislative levers the CPIB uses, in particular the Prevention of Corruption Act, are being reviewed to keep them relevant in the fight against corruption. Thank you. Mr. Deputy Speaker, sir. First, I'd like to thank Mr. Murali for his trust in CPIB as a tenacious and effective agency against corruption. Indeed, for the past 69 years, CPIB has been unwavering and relentless in its efforts to fight corruption. Other than the political will to fight corruption, heavy punishments, and the effective anti-corruption laws, as well as public support, these are all very important factors contributing to the low corruption in Singapore. While the PCA has and continues to serve us well, CPIB will regularly and proactively review the provisions to make sure that the Act is able to keep pace with, if not stay ahead of the evolving threats. To the member's question, I can share the following areas which CPIB is working on with respect to the PCA review. First is to ensure that the punishment for PCA offences are in line with those of other economic crimes. Second, to conduct comparative studies on international legislations to assess, amongst other things, if there's a need to have separate punishment for corporate bodies. Third, to review the need to expand the current extraterritorial provisions by examining past cases where CPIB is not able to take actions on foreigners performing outsourced law enforcement functions where the corrupt transactions were undertaken overseas. Mr. Deputy Speaker, sir, I mentioned in my reply earlier that Singapore's clean and corruption-free reputation should not be taken for granted. Indeed, we must not let our guard down. Low crime does not mean no crime. Likewise, low corruption does not mean no corruption. Corruption, if embedded and become endemic in our society, will alter the fundamental DNA of our societal ethos that have been painstakingly built up over the past many decades. This threat will then diminish the trust and confidence that Singaporeans and others have in each other and in our system, eroding the work ethics and tearing our social fabric apart. So to Mr. Murali's comment that, yes, indeed, in some of these corruption cases, it is a win-win situation for the person providing the bribes and for the person receiving the bribes. But the victims are actually the whole society and our own ethos of what we stand for as a nation and as a people. So the damage goes beyond what may be transacted between the two perpetrators. So this is why that while CPIB has done well in its work all these years, as a society we need to maintain our vigilance. The threat is always evolving, especially with technological advances and evolving corrupt practices. It is thus important to ensure that the DNA of incorruptibility is ingrained in every Singaporean, young and old. CPIB has been educating our youth and working with them to co-create public education resources for the youth by the youth. Some of these initiatives have been mentioned in my earlier response. Ultimately, businesses must remain fully confident that they can plant their investments here in Singapore because our rules and processes are fair, coherent, and transparent, thereby creating quality jobs for fellow Singaporeans. And our people must always believe that they can succeed because of their honest and hard work. This brand of incorruptibility is also what allows Singapore and Singaporeans to stand tall amidst the global competition, even beyond our shores.
Next question, please.
Deputy Speaker, sir. On 17 April 2021, the Sumatra squall, coupled with convergence of surrounding winds arising from the influence of Typhoon Surigay near the Philippines, gave rise to intense and prolonged rainfall across Singapore. The highest rainfall that day was at Ulu Pandan, with 170.6 millimeters of rain. This is the highest daily rainfall recorded in April since 1980, and is equivalent to 110% of Singapore's average rainfall for the whole month of April, falling in a single day. This rainfall resulted in flash floods occurring at Bukit Timah and Dunearn Roads near Sime Darby Centre and a stretch of the park connectors along Ulu Pandan Canal. With your permission, Deputy Speaker, may I display some slides on the LED screens?
Please do.
This is a map of the stretch of roads I mentioned in my reply. Just a bit of landmark. Sime Darby Centre is the block marked in black. The water levels in Bukit Timah Canal were very high due to intense and prolonged rain, impeding discharge from roadside drains along Dunearn Road and Bukit Timah Road into the canal. This resulted in floods of around 150 millimeters of depth at Dunearn and Bukit Timah Roads, and around 50 millimeters depth on the pedestrian sidewalks adjacent to the roadside drains. All affected roads remained passable to traffic, and the flash floods subsided within 30 minutes. PUB Quick Response Team were on site directing traffic and assisting affected residents by issuing inflatable flood bags and portable flood barriers to prevent floodwaters from entering their homes. PUB had completed the upgrading of the Bukit Timah First Diversion Canal. This is the stretch marked in blue between Bukit Timah Road and Clementi Road in September 2019 at a project cost of $300 million to alleviate flood risks along Bukit Timah Road and Dunearn Road. Members who have been on the rail corridor hike would not miss this impressive infrastructure. It's somewhere along, after you have crossed Bukit Timah Station, railway station, another 500 meters or so, you will come to this stretch, which opens out to the area Old Holland Road. So it's impressive because it's large and it's deep, and I think has helped significantly on this day of 17 April, because the flood this day is nowhere near the earlier floods that we have seen along the same stretch of road when lesser rain fell on that day. Water level sensors on this stretch, the sensor is placed where the yellow triangle is located, installed along the upgraded stretch of Bukit Timah Canal from Jalan Kampong Cantik to 6th Avenue, just upstream of the expanded Bukit Timah First Diversion Canal, showed the section of the canal was 50% full on 17 April, with no flash floods along that stretch despite the heavy rainfall. PUB started the upgrading work on the section, the remaining section of Bukit Timah Canal between Rifle Range Road and Jalan Kampong Cantik. This is the stretch marked in red, where the localized flash flood occurred, and is expected to complete it in 2024. When completed, we expect the top water level in this section of the canal to be lower by over 1 meter for the same rainfall intensity experienced on 17 April. Another stretch, which is along Ulu Pandan Canal. A low-lying 300-meter stretch, it's marked in red, of the park connector next to the Ulu Pandan Canal was also flooded on 17 April, even though the major roads are Clementi Road in grey, Clementi Avenue 6, Commonwealth Avenue West, and the AYE served by the canal did not experience flooding. PUB will raise this low-lying section of the park connector when PUB reconstructs the Ulu Pandan Canal in tandem with future developments. Since 2011, the government has invested almost $2 billion in drainage works and will invest another $1.4 billion over the next 5 years to enhance our flood resilience. Drainage design standards were also raised in 2011 to cater for higher intensity rainfall as part of PUB's broader efforts to address the impact of climate change. It is, however, not practical to expand our drains to accommodate every extreme rainfall events, as this would require massive land take and much higher costs. PUB will put in place cost-effective measures to minimize flood risks and better manage flood events. For instance, PUB is currently upgrading its rainfall forecasting radar technology, which will help improve prediction of locations where heavy rainfall might occur and enhance response time to potential flash floods. PUB also works closely with LTA and traffic police during heavy storms to monitor road conditions and notify motorists of flooded roads to avoid. Let me repeat that. PUB also works closely with LTA and traffic police during heavy storms to monitor road conditions and notify motorists of flooded roads to avoid through electronic road signages, online and social media platforms, and radio broadcasts. Members of the public can be alerted on flash floods by subscribing to NEA's and PUB's weather forecasts and water level SMS alerts, or access the mobile app MyENV for updates on impending heavy rain and the water level in drains at designated locations.
No supplementaries. Dr. Lim Wee Kiat.
Sir, all Singaporeans and permanent residents are covered under our national Medishield Life health insurance scheme. Medishield Life is universal, covers pre-existing conditions, and provides basic protection against large healthcare bills.
Excuse me, SMS to confirm, are you taking 24 to 31?
I beg your pardon, sir. Yes. Can I take 24 to 31 together, please,
Yes,
sir?
please proceed.
if I may continue, sir, MediShield Life can be used both in public and private healthcare institutions, and coverage is sized to be sufficient for subsidized care. The government provides means-tested subsidies for MediShield Life premiums, and MediSave can be used to pay for premiums to keep them affordable. Individuals may choose to purchase an integrated shield plan, IP plan, which provides additional benefits beyond MediShield Life to provide more coverage for private healthcare services. MediSave can be used to pay for IP premiums subjected to withdrawal limits to help defray the cost of private insurance. Currently, less than 1% of Singapore residents have a standard IP plan. 10% have a Class B1 IP, 20% have a Class A IP, and 40% have a private hospital IP. In addition, some individuals may also purchase riders on top of their IP plans if they prefer additional coverage and can afford the premiums. Riders commonly cover the deductible and co-payment portions of the bill. Riders are fully private insurance products that must be paid by cash, and MediSave withdrawals are not allowed for rider premiums. Less than half of Singapore residents have riders. So let me just summarize this part. In essence, MediShield Life is universal. It's sized to cover the bulk of the large hospitals for subsidized care. IP plans stay right on top of this to provide for hospital bills, and riders go even further on top of the IP plans to cover for the deductibles and the co-payment. So it is almost, you can see, as a three-tier thing. MOH does track and monitor the bills from both public and private healthcare institutions. Private healthcare costs have been rising rapidly in Singapore. Between 2007 to 2019, private hospital bills among IP cases grew at 4%, twice as fast as unsubsidized bills in public healthcare institutions. In both private and public hospitals, investigations, surgeons' fees, treatment services, and operating theatre facility fees were key drivers of cost growth for private patients. In 2016, the Health Insurance Task Force, HITF, comprising members from the Singapore Medical Association, the SMA, Life Insurance Association, the LIA, Consumers Association of Singapore, CASE, MOH, and MAS, had recommended various measures, such as paneling and fee benchmarks, to help contain claims, I beg your pardon, let me say that again, to help contain claims and healthcare cost escalation. MOH has been working to implement the HITF recommendations. Fee benchmarks have been rolled out since 2018, along with appropriate care guidelines. One of the recommendations from the HITF was to introduce a minimum co-payment requirement, as IP riders that fully covered deductibles and co-payment had contributed to rising private healthcare costs. The co-payment ensures what we call skin in the game, to encourage patients and their doctors to make careful and deliberate treatment decisions on the choice of treatment and the type of care they need. MOH therefore introduced a minimum 5% co-payment for all new private riders in 2018. The IP insurers have also extended this requirement, or alternative claims-based pricing, from April 2021 to their existing policyholders with riders. While this is not a requirement imposed by MOH, the Ministry does support the move, as it will help to encourage appropriate care. To provide some assurance to policyholders who are concerned with potentially large co-payments, MOH therefore allowed insurers to apply a $3,000 co-payment cap for treatment from panelled doctors with a negotiated fee arrangements with insurers. This would mean that bills above $60,000 are capped at $3,000 co-payment. To put things in perspective, less than 3% of inpatient bills in private hospitals today exceed this $60,000. So the vast majority of inpatient bills do not actually hit the $3,000 co-payment cap. This co-payment cap could not be applied to all claims, as it would negate the effect of co-payment once the $3,000 cap was reached. Let me explain. Take, for example, if the co-payment applies to all claims, policyholders may choose a treatment which costs $100,000 instead of another equally effective treatment at $70,000. This is because the policyholder would pay the same amount of $3,000 for either option once they breach the $60,000 limit where the $3,000 payment cap has been reached. The additional costs would then be borne by the insurer, and this eventually translates to higher premiums for other policyholders. Therefore, the cap was applied to panelled doctors, where there are established fee arrangements to ensure that appropriate and cost-effective treatment is provided. Some have raised concerns with regard to the use of panels. Questions have been raised on whether limited panel sizes are in the best interest of the patients, and whether such practices are anti-competitive in nature, or if there are medical ethical concerns around such practices. The use of panels was recommended by the HITF. Internationally, panels have been used by some countries to keep healthcare costs more predictable, to reduce variation in practices and charging. These practices do not contravene the Competition Act, as any decision to empanel doctors is made by individual insurers independently with the doctors on mutually agreed and acceptable terms. Such practices do not restrict insurers from competing with one another on their prices, insurance products, or choice of doctors. Nevertheless, MOH has encouraged insurers to make their panel selection criteria more transparent, a move that is also supported by the LIA in its Panel Good Practices Guide to all insurers. On the issue of medical ethics, the Singapore Medical Council's Ethical Code and Ethical Guidelines stipulates that doctors should have the best interests of their patients at heart when treating them. This includes prescribing appropriate and cost-effective care that best meets the needs of their patients. Access to medical care and clinical judgment should therefore not be influenced by empanelment, nor any other financial constraints or pressures inherent in any health system. Should doctors find that the conditions of being on the panel would impose constraints on their ability to care for their patients, they may decide for medical ethical reasons to not participate in such panels. We want to emphasize that patients can make claims for all treatments covered under the IP, regardless of whether the specialist is on the panel or not. Nevertheless, some doctors have expressed concerns that IP panels do not have an adequate number of specialists, restricting referrals to the appropriate specialists who may not be on the panel, and therefore limiting the continuity of care. Patients have also raised concerns that the doctor they are comfortable with or are familiar with is not on the panel of their IP insurer, and they may not enjoy the additional benefits such as the $3,000 co-payment cap. To address this, MOH has encouraged all insurers to grow the size of their panels, and some have already increased the number of specialists on their panels by more than 40% since August 2019. Today, more than 70% of private specialists are on at least one IP panel. Some have asked insurance panels to be expanded to include all doctors, so long as they do not have a poor track record with the Singapore Medical Council or SMC. However, some doctors may choose not to be empaneled, as they may already have a sufficient pool of patients, so the doctors do have a choice to not be on panels. This is especially the case for areas where there are very few specialists locally. Hence, MOH encourages IP insurers to enhance their pre-authorization processes, to give approval for hospitalization or treatments and their associated costs beforehand. With pre-authorization, insurers are able to assess treatments for medical necessity and fee arrangements and appropriateness, including for doctors who are not on their panel. And patients can also have the greater peace of mind knowing that at least a significant portion of their bill will be covered by their IP. With pre-authorization, the risk of runaway bill sizes would then be minimized. Hence, some insurers have extended the co-payment cap to pre-authorized claims for treatment by non-panel doctors to provide policyholders with greater assurance, and we certainly encourage more to do so. While policyholder benefits may differ depending on whether they see a panel doctor or a non-panel doctor who is pre-authorized, these benefits should not differ to the extent of prohibiting patients from seeing non-panel doctors or influence patient choices in an undesirable way. MOH recognizes that some policyholders may wish to switch insurers, whether for more competitive premiums or for better benefits such as access to more panel doctors, but are unable to do so because of pre-existing conditions. IPs are commercial products, and their features and pricing are ultimately determined by private insurers. MOH will study whether IP insurance can be made fully portable, including looking at examples abroad. However, insurers may potentially need to increase the premium significantly for all policyholders to price in the increased risk they assume for portable IP that covers pre-existing conditions. This is why MediShield Life is designed as a scheme to cover all Singaporeans for life with no exclusions and covers all pre-existing conditions to give reassurance to all Singaporeans should they choose to relinquish their private IP plans for whatever reasons. Over the last 5 years, about 5% of IP policyholders relinquish their IP per year on average. This could be because they may have opted for different coverage after considering the cost of the premiums, their financial resources, and their different healthcare needs. Their average age was 34. Data on the number of policyholders who did not subsequently purchase a new IP or were later admitted to public hospitals is not available. Consumers should understand their IP terms and conditions when choosing their IPs. Insurers offer policyholders enhanced policy benefits such as the co-payment cap, lower deductibles, or a longer period of pre- and post-hospitalization coverage for panel treatments. All this must be made known to the policyholder prior to policy purchase and at least 30 days before any changes in policyholders' benefits. Policyholders must be properly advised at the point of purchase or renewal about their coverage so they can make informed choices about their IP and choice of doctors and care setting. Some have asked if insurers can simply use MOH's fee benchmarks to determine all insurance payouts. As fee benchmarks are designed to be reasonable ranges of fees for the large majority of cases, insurers can generally take reference from the benchmarks for most payouts. Doctors do charge below and above the benchmarks depending on the nature and the complexity of the cases. However, insurers also need to take into account the medical complexity and specific clinical circumstances and deviate from the benchmarks for justifiable and exceptional cases. According to LIA, between 5% to 15% of IP claims for certain fees were approved above the upper bound of the fee benchmarks, depending on the insurer. Claim scrutiny by insurers may have been perceived as challenging a doctor's professional judgment. Insurers scrutinize claims to ascertain whether treatments were medically necessary and charged appropriately. This actually protects the interests of policyholders who may otherwise see their insurance premiums rise should claims be paid out indiscriminately. MOH recognizes that this is an important process for the integrity of the healthcare system, and it is a common practice internationally. It is nonetheless important that the process be handled professionally and efficiently by each insurer. Insurers should not make the process onerous and ask for unnecessary information unrelated to the claims, imposing a heavy administrative burden on the doctors. The questions and information sought for common conditions can be standardized and streamlined, so it will not be perceived as questioning the decisions and judgment of the doctors. If a particular claim is justified, insurers should pay according to the policy benefits. We will be looking more into this issue. Dr. Tan Wu Meng has raised concerns with the risk of IP insurers exiting the market. To ensure that insurers remain financially sound and are able to meet their obligations to policyholders, MAS exercises regulatory oversight over the insurer's financial standing, risk management, and governance. This is accomplished through measures such as establishing regulatory capital requirements and setting corporate governance and risk management requirements and guidance, which are in turn reinforced by regular on-site inspections and close engagement with the boards and senior management of insurers. MAS also takes action against insurers whose practices are found to be wanting or where there are breaches of MAS's regulation. An insurer may decide to exit the IP market because of commercial reasons or due to insolvency. In the event that an insurer exits the IP market, the insurer or the liquidator will seek to arrange for the IP policies to be transferred to another insurer for continuity of coverage. MAS will ensure that the existing insurer and the insurer taking over the IP policies properly account for policyholders' interests. The various initiatives covered above will take time to bear fruit. However, we are confident that these measures will help to keep healthcare costs more sustainable. Looking ahead, the refinement of various IP features will continue to be a multilateral effort between MOH, hospitals, doctors, and the insurers. To support these efforts, MOH appointed a 12-member Multilateral Healthcare Insurance Committee, or MHIC, in April this year to provide a platform for healthcare providers, payers, consumer representatives, and the government to work on these issues related to health insurance. The MHIC comprises representatives from the Academy of Medicine Singapore, AMS, the Consumer Association of Singapore, CASE, the Fees Benchmark Advisory Committee, the Life Insurance Association, LIA, the Singapore Medical Association, SMA, private hospital representatives, and with the Monetary Authority of Singapore as an observer. For a start, the committee will prioritize 4 specific work streams. First, panels and pre-authorization, including streamlining the processes I spoke about earlier. 2, issues pertaining to improving transparency across the board, including providing more detailed and itemized information about healthcare bills and publishing data on claims and premiums so that insurers, providers, and policyholders can make better informed decisions. 3, establishing a claims complaints process supported by AMS and LIA so that stakeholders have an avenue for recourse should they feel unfairly treated, such as where insurers or patients may wish to raise concerns about over-servicing or overcharging, or if doctors have concerns about certain insurer practices. And 4, examining the issues from a patient and consumer-centric viewpoint to ensure that the patient and public interests are best safeguarded. On this particular last issue, CASE will be leading a subcommittee to the MHIC to deal with the matter comprehensively. As these issues are complex, some time will be required for the committee to develop and agree on practical solutions. Processes within the institutions, hospitals, clinics may also have to be adjusted to make it more seamless and streamlined. The committee has already begun its work with the first meeting held on 27th of April. MHIC will share its recommendations progressively as they are ready and is working towards a first round of recommendations in the next few months. The issues surrounding IPs are multifaceted and require thorough discussions as well as careful balancing of various considerations to find solutions that best benefit policyholders and patients. With continued healthy dialogue through the MHIC, MOH will work together with all stakeholders towards developing sustainable solutions for policyholders, payers, and providers alike. Thank you, sir.
Mr. Pritam Singh.
Thank you, Deputy Speaker. Thank you, Senior Minister of State, for the extended comments on this issue. The recent public exchange between the Singapore Medical Association and the Life Insurance Association of Singapore has put into focus the role of the regulator, namely MOH. Even as I acknowledge SMS's establishment of the MHIC, which has been set up to look into some of these issues, I have nonetheless 2 supplementary questions for the SMS. Firstly, would MOH, as the regulator, be amenable to setting up a database transparent to both doctors and insurers to allow parties to compare and assess their bill sizes with a view to better manage medical inflation in the public interest? The second supplementary question is in conjunction with the first, which is, together with the establishment of the database, would MOH as regulator consider setting up an independent panel of assessors under its purview, which would be accessible to patients, doctors, and insurers to resolve disputes about fees and the necessity of medical procedures? Thank you.
So I thank Mr. Singh for his questions. In fact, these two items are actually already being done. The first one on the database for bill sizes, when we have the fee benchmark advisory committee, in fact, the database on fees that are charged across a diverse range of procedures across various institutions are already available for the committee, which comprises of practitioners and insurers to actually collectively deliberate on what the kind of benchmarking ought to be. So yes, the database is available, and I think that will provide some scrutiny by the relative stakeholders to ensure that whether it's payouts, whether it is benchmarking, considered fair to the policyholders and to the payers as well. The second issue on independent assessment, as you hear from my reply earlier, we will be setting up a claims complaints panel that comprises of the insurers plus also the Academy of Medicine of Singapore, which are specialists in the respective fields. So that provides some degree of independence from the professional side of both the stakeholders to really look at any areas in which, whether it's insurers or doctors, have got some unhappiness over the way payments are done or the way a certain case is being assessed by either party. So yes, there will be an independent panel that is really going to be in the works.
Thank you, Deputy Speaker. Let me thank the SMS for his answer. Definitely limiting the choice of doctors for patients and insured individuals. Personally, I feel that definitely this is to the disadvantage of to the patient. I can't understand how this is not anti-competitive. By limiting choice to the patient itself, this will limit patients' ability in terms of choosing the right doctors. Unless you are telling me that the empanelment, which means that our panel itself comprises more than 50% of all doctors in Singapore, to make sure that each insurer must have a certain percentage of doctors on it. Second thing is that if the purpose of empanelment is to control fees, doesn't your fee benchmark already does that already? With the fee benchmark in place itself, then can we remove the panel completely? That's something that you will consider about. Last of all, on this point, I also do agree with our leader of opposition. Will MOH be coming up with the ranking of the insurers? Because MOH will be seen as a neutral party to this itself. I think this is to protect the consumer. Thank you.
So I thank Dr. Lim for his questions. Now, I think the issue of whether the limited size of certain panels within certain insurers, I think, as I said in my reply, it will be very difficult to say that we make the panels 100% because doctors have a choice not to be on panels as well, right? And I think the more important way to look at this is how can we make sure care is accessible to all patients, whether the mechanism is empanelment or otherwise. I think that the key is to make sure patients have access to any doctor they want to see, which is why I think the better way to go for is actually look at pre-authorization. With pre-authorization, the doctor puts in his diagnosis, gives a certain quote on the treatment cost that is needed, and the insurer have a chance to see whether this cost is fair and whether the type of treatment that is proposed is reasonable for the kind of diagnosis that is being put forth. And I think in that sense, then patient can have access to any doctor subject to a pre-authorization if they are not on panel. And I think this is a mechanism that is already available today, but what we need to do is make sure the process is much more streamlined and seamless so that there is not too much administrative burden on the clinics and the patient doesn't have to wait too long for this process to be completed before they can access to care by a different doctor, by a different specialist. In terms of ranking of insurers, I think what's important is to have this information on how each insurer price their policies and what benefits they have transparently so that patients or policyholders themselves can make a comparison and take a look. It's very hard to say which is insurer ranked number one or which is ranked at the bottom because they may have product differentiation that meets different person's needs. And for a person where the product meets his needs, he could be number one as an insurer. But if the other product meets the other person's needs better, that could be number one in the other person's eyes. And I think it's very hard for MOH to decide from one person to the next which is the best product to suit the person's needs. What we should do is put up more information so that patients and policyholders can make the right informed choices.
Dr. Tan Wu Meng.
Mr. Speaker, I thank the Senior Minister of State for his detailed answer. I'd like to raise supplementary questions along two themes: patient voices and patients' ability to negotiate in the market. On the issue of patient voices, Mr. Speaker, can the SMS assure us that MOH's proposed dispute resolution mechanism will actively involve the patient perspective and the journey experienced by patients, whether as existing policyholders navigating the IP system or potential policyholders or former policyholders who may feel excluded? My Clementi residents who are on integrated shield plans, some of them, they tell me of the challenges involved in making a claim despite having been with the same firm for many years, despite the full support of the doctor looking after them, whether the doctor is in the private or public sector. On the second question, Mr. Speaker, that of the bargaining power of patients and policyholders and consumers. The SMS earlier spoke about the scenario of what happens if an IP insurer exits the market. He said that there would be a negotiation or discussion between the agencies and the insurance provider about ensuring that patients are covered. But I asked the ministry, in the event of an IP insurer exiting the market, is there a mechanism to ensure that patients who already have existing conditions will be appropriately covered and recognized in a way that does not disadvantage them if the insurer exits the market? I furthermore would like to ask MOH whether MOH will consider establishing some kind of regulatory backstop to protect patients, because once you have a mechanism in policy to protect patients when an insurer exits the market, to allow these patients to transit in a way that is non-discriminatory, not unfavorable to another insurer, I put it to the ministry that can be the beginning of a mechanism to allow patients to transition between insurers. And I suggest to the ministry that once patients have the option of transiting with the potential for having pre-existing conditions covered to some extent, as in the case in other regulatory jurisdictions like Australia, there is better bargaining power for the consumer, and that leads to a better functioning market as well. Thank you.
So I thank Dr. Tan for his clarification and questions. On his first question pertaining to patient voices, should there be a dispute by the policyholder against the insurer? What mechanisms are there today to address some of these grievances? Actually, today, FIDREC, the Financial Dispute Resolution Center, has already a mechanism in place to address any policyholders' concerns pertaining to whether it's their policy terms or unfair treatment by their insurer. So FIDREC is a mechanism that's already available, but we do feel that with the better patient public education, that will actually raise the awareness of the consumers' rights and when they think that their rights under the policy terms have been violated. So better patient education, better policyholder education is another important thrust to get this done. So we welcome the fact that CASE will be forming a subcommittee under the MHIC to further study this issue and also to look at how they can better represent the voices of consumers, policyholders, and patients. On the second issue on the what would happen if the insurers were to exit the financial sector. Now, if an insurer fails and undergoes winding up processes under the Insurance Act, the appointed liquidator is required to endeavor as far as possible and reasonably practicable to sell or transfer the whole or part of the insurance business to another insurer before considering other options. The Policy Owners Protection Scheme, or PPF scheme, is also in place, which aims to provide coverage for policies which are commonly purchased by consumers and or cause significant impact or disruption to policyholders should the insurer fail. This would include accident and health policies such as IP plans, which will be fully covered under the PPF scheme in an event that the insurer fails. The PPF scheme does not merely provide compensation of crystallized claims when an insurer fails, but also seeks to ensure continuity where possible for the affected policyholders in the event of an insurer's failure. For example, it could also fund a transfer or run off of the IP portfolio business to another IP insurer to ensure continuity of coverage for the affected policyholders if necessary. And in Singapore, what is useful for Singaporean citizens is to always know at the back of their mind that they have a safety net called MediShield Life. Should all else fails, MediShield Life will be here to cover you universally with no exclusion on all your pre-existing conditions for life.
Mr. Yip Honring.
So, Deputy Speaker, sir, I thank the SMS for his reply. I just have one SQ, which is whether this method of empaneling doctors will impact patients who may need to change doctors halfway during their treatment for whatever reasons. Thank you.
So I think this is also in the same vein as the expanding the panel of doctors, which is why one of the work stream that the MHIC endeavors to do as one of their earliest priorities to look at how they can further expand and streamline the pre-authorization process. I think once we can get a more seamless and streamlined pre-authorization process, effectively opens up access to care for all doctors. And the patient then don't have to really worry about so much about whether you're panel or non-panel. The difference, of course, is in some of the benefits for panel and non-panel doctors, but today, any IP-insured patient can actually have access to non-panel doctors through pre-authorization already. So at the moment, there is actually no restriction of care, but there is some friction in the process. So with pre-authorization, hopefully we can make this much more seamless and reduce a lot more anxiety for a patient going for treatment when they have to go beyond a panel to access specialists outside the panel. So I hope that will help the members to understand that the MHIC will prioritize this as one of the key streams they want to work at.
Okay. Mr. Gerald Giam.
So, private hospitals house less than 17% of hospital beds in Singapore. And the SMS just replied to my question and said that 40% of Singaporeans hold an integrated shield plan for private hospital coverage. This points to a rather high proportion of voluntary downgrading by patients, meaning that they are eligible to seek treatment in private hospitals, but end up going to public hospitals. Does the SMS think that Singaporeans are overinsured for private insurance, which they don't use? And secondly, are there plans to better educate Singaporeans about their options of different integrated shield plans so they don't get all the information from insurance agents who are trying to sell them private hospital plans?
So I thank the members for his questions. I think the second question is easier to answer. We'll just put out as much information as possible, whether it's on the MOH website, whether it's on the LIA website, and of course, CASE can play a stronger role in patient and policyholder education as well. But I think for his first question, he's conflating two different numbers together that doesn't quite necessarily gel. Just because there are only 70% of hospital beds doesn't mean 40% of people cannot buy insurance for private sector. It doesn't mean that everybody who buys a policy gets sick and gets admitted to the hospital all at the same time. Right? And so it is a choice to buy. It doesn't necessarily mean that they will necessarily have to consume. And it doesn't necessarily mean that the size of the number of beds we have should then limit the amount of policy coverage a particular segment of population goes for. I hope that helps him to understand why the numbers should not necessarily be conflated together.
Dr. Tan Wu Ming, you just make it a very short supplementary, and then we'll move on to the next topic.
I thank the SMS for its further clarifications. I want to put on record as a declaration that I'm a medical doctor looking after patients in the public sector for avoidance of ambiguity. I thank the SMS again, and I very much support any further analysis of this issue by the Ministry and look forward to updates in due course. Thank you very much.
Mr. Alex Yam, next question, please.
May I have your permission to answer PQs 32 to 36 together?
Please do.
As well as Dr. Wan Reisel's PQ scheduled for a subsequent sitting.
Please do.
Thank you. Last month, there were 2 unfortunate accidents involving lorries that were transporting workers. The first occurred when the lorry ferrying 17 workers collided into a stationary truck along the Pan Island Expressway and resulted in 2 fatalities. The lorry driver has been arrested for careless driving causing death. The second incident involved a lorry ferrying 9 workers, but fortunately, there were no fatalities. 3 days ago, there was an accident between a police van and a lorry ferrying 11 workers. 17 people, including 5 police officers, were conveyed to the hospital with minor injuries. We are deeply saddened by the accidents and would like to offer our deepest condolences to the affected families. The accidents are currently being investigated by the traffic police. The party or parties found responsible will be dealt with based on our laws. Members have raised concerns on the use of lorries to ferry workers. Internationally, practices are varied. Countries such as Canada, Thailand, and the United States of America allow for passengers to be ferried in the rear deck of goods vehicles traveling on roads, albeit with safety precautions and some restrictions. From a road safety perspective, it will be ideal for lorries not to carry any passengers in their rear decks. But there are very significant practical and operational issues on top of just cost considerations, which is probably why internationally it is not an uncommon practice. I want to assure members that we take seriously the safety and well-being of all workers, including our foreign workers, without whose contribution Singapore will not be what it is today. As far back as 2008, a work group co-chaired by the Ministry of Manpower and the Land Transport Authority conducted a thorough review of the safety of workers being transported on lorries. The work group included members from industry associations, the National Safety Council of Singapore, traffic police, and other government agencies. Over more than a year, the work group studied the issue extensively and consulted widely, including industry groups, safety experts, and transport operators. At that time, companies, especially small and medium enterprises in the construction industry, had strongly urged the government to allow them to continue ferrying their workers in lorries. The industry associations also provided strong feedback that switching to dedicated bus transport will lead to significantly higher business costs. Other practical challenges were also highlighted. For instance, while lorries can have dual use for transporting workers and equipment, buses cannot, and this will result in significant productivity loss. Other proposals, such as using vans with smaller capacities or lowering the cap on deck capacity, were also considered. But there were concerns about driver fatigue and therefore safety, as more trips will have to be made to ferry workers from one site to another. The work group studied the various feedback carefully and laid out a set of recommendations to preserve workers' safety and livelihoods. As a result, the government implemented enhanced safety measures for lorries ferrying passengers in 2009 and 2010. These include fitting higher protective side railings and canopy covers and higher penalties for non-compliance, up to 5 times more. The work group's recommendations aim to protect not only the workers' safety, but also their livelihoods, which was a difficult challenge. Since then, we have continued to review and refine our regulations. For example, since 2015, all S-Pass and work permit holders are required to pass the necessary theory and practical driving tests before they can obtain a Singapore Class 3 license that will allow them to drive light goods vehicles, including those which transport workers in the rear decks. Over the last decade, the number of persons on board lorries who were injured or killed in road traffic accidents has been on a downward trend. In 2019, the injury rate of persons on board lorries is about 8.1 per 1,000 lorries, which is lower than the injury rate of persons on board all motor vehicles at 8.4 per 1,000 motor vehicles. In 2020, traffic volumes were lower due to COVID-19 restrictions, and the injury rate of persons on board lorries was about 4.5 per 1,000 lorries, compared to 5.6 persons on board all motor vehicles per 1,000 motor vehicles. For this year, up to March, the injury rate of persons on board lorries is about 1.5 per 1,000 lorries, comparable with that for persons on board all motor vehicles. Data for the full month of April 2021 is not yet available. The number of persons on board lorries who were killed in road traffic accidents has also been on a downward trend. From 2011 to 2015, an average of 9 persons on board per year were killed in road traffic accidents. This dropped to 2.6 per year from 2016 to 2020, or 2.5 if we exclude 2020. That said, declining injuries and fatalities from such accidents should not make us complacent. One life lost is still one too many. Back in 2008, the work group had thoroughly considered how to prevent this, and many of the suggestions raised by the members today were previously studied by the work group. For example, the work group found that retrofitting seat belts in the rear decks of lorries could result in other safety risks. This is because commercially available lorries are not designed for seat belts to be installed in the rear deck, and the floorboards in the rear deck might not be sufficiently strong to keep the seat belts anchored in the event of an accident. Compared to 10 years ago, regulatory changes at this time will cause even more acute pain to the industry, given that the industry is being severely affected by COVID-19. Worker supply has been disrupted, leading to severe manpower shortages. Projects are already delayed, and productivity has been affected because of safe management measures. Further regulations will likely have impact on the completion of various building projects, from BTOs to MRTs to nursing homes and hospitals, spell the demise of some companies and the loss of workers' livelihoods. We cannot simply ignore these considerations. Notwithstanding the improvement made over the years, one fatality, and in fact one injury, is still one too many. We appeal to all road users to drive safely and responsibly. The government will continue to conduct public education so that lorry drivers and owners are reminded of the rules. LTA has also been stepping up enforcement to catch errant owners and drivers. The government will continue to refine our policies and regulations to further minimize such situations involving our workers. We have brought down the accident rates of lorries over the years and will continue to strive to do so. We note the concerns regarding this issue, and understandably so. But this is an issue with multifaceted considerations and wider ramifications, including on workers' livelihoods. We will continue to review the safety rules, engaging the various stakeholders along the way to see how to enhance these measures further. Meanwhile, I urge all employers to do their part to ensure the welfare and safety of their staff. Members of the public can also call LTA's hotline to report any non-compliance with safety regulations.
Mr. Alex Yam.
Mr. Deputy Speaker, I thank the Senior Minister of State for her response. We often quote trade-offs and costs as part of our decision-making matrix. But I think for the families in the recent accidents who have lost their sons in Singapore, I think that cost would surmount all other costs that we talk about. The SMS spoke earlier about the work group back from 2010. It's been over 10 years already. Would the ministry consider, therefore, reconvening another work group to restudy new proposals as well as improvements in vehicle designs over the last 11 years that could potentially have new solutions to improve safety on board lorries? In terms of other safeguards, there have been substantial studies internationally on the constraint of speed and how that would impact results out of accidents. So therefore, would the ministry also consider safeguards such as constraining speeds of lorries for the time being until new solutions can be found to perhaps 40 kilometers per hour so that it significantly improves survivability as well as safety at this speed. In terms of seat belt, I hear what the SMS has said, that the design of the lorry, so on and so forth. We've done that for the SAF. We've introduced seat belts to our 5-tonners. Over and above that, will the ministry also consider requiring owners and operators to also tie down the equipment that they transport together with the workers, because it's often these free-flying projectiles in an accident that caused a significant amount of injuries.
SMS.
I thank the member for his questions. Let me reiterate again that passenger safety is very important. We agree with that. And as I've said earlier, every fatality and every injury is one too many. And we do want to continue to strive to enhance and preserve the safety of our workers when they are using the roads or when they are being ferried. But as I've also noted in my answer earlier, this is a multifaceted issue with many ramifications. And indeed, even as we consider all these issues, we need to be also mindful that we need to find a balanced and calibrated approach in order to preserve the safety of workers as well as their livelihoods. With regards to the further questions on the various measures that could be taken, firstly about convening a work group, as I've said, we have been monitoring the situation even since the last review, as well as refining the measures. So in 2015, we have actually introduced this requirement of not just getting the foreign workers to take a basic theory test, but also to pass our Class 3 driving license if they want to drive the Class 3 vehicle. And we are currently undertaking a review of the measures with a view of looking at how we can enhance these measures further in order to improve safety for workers. We will need some time to engage the various stakeholders, and we will take into account all the suggestions and proposals made forth. We actually look forward, including to working with the tripartite partners, the industry and unions on this, to find the way forward, a sensible and sustainable way forward. Regarding speed limits, presently, vehicles, such light good vehicles, already have a speed limit of either 60 kilometers per hour or the posted vehicle speed for that area, whichever is lower. And this is already well below the speed limit of 90 kilometers per hour on the expressway. So further reducing this speed is actually not recommended by the experts. because when you increase the speed differential between the lorries and all the other motor vehicles on the expressway, it can lead to other safety issues. For instance, the increased tendency for overtaking maneuvers, which can increase the risk of accidents. With regards to the study that the member talked about, perhaps it could be one by, it's a Swedish study, which actually really talks about the impact of the vehicle on passengers if an accident were to occur, and that it will be less likely to cause serious and fatal accidents, injuries, if it is below 40 kilometers per hour. So that's really about the impact on the passengers if it's below. But here we also need to consider the potential, the increased potential of a risk of accident in the first instance, if we were to reduce, increase the speed differential. But having said that, as I've said in the review that we are undertaking, we'll consider all views and suggestions, and as what the members say, there may be other areas that we can look into. In regards to tying down equipment, actually under the Act, as well as guidelines issued by the Workplace Safety Council, the employers are already required to safely tie down the equipment or goods, or load the equipment or goods safely, so that it will not be a danger to the passengers. That is actually already a requirement. In fact, there are actually guidelines about loading the goods safely. And if in fact the lorries actually has goods or equipment, then the deck space allowable for ferrying the workers will be correspondingly reduced. I think I've covered the members' queries. Thank you.
Ms. Hartingro.
First, I'd like to thank the SMS for her commitment towards safety for our migrant workers. The SMS mentioned earlier that there will be a consultation with various stakeholders. So I would like to know whether the question I asked about studies to be done about how much costs will be increased by increasing any safety measures, whether there are any studies done, whether such studies will be done, so that we can have a more informed discussion. Because every time we bring this topic up, we hear the counter argument saying it will be increased costs. So we need to actually understand how much cost will be increased by before we can actually have a meaningful conversation about whether or not there will need to be further safety measures put in place. The second point that I want to have ask a SQ on is really, the SMS mentioned earlier as well that ferrying workers at the back of lorries is actually something that's done in other countries. But I note that this is not the case in all other countries. So I would like to know whether there's a study actually can also be done into those countries that outlaw this sort of practices, and to find out what sort of ways they actually use to actually overcome some of the costs and practical and operational issues that the SMS actually mentioned earlier. Thank you.
Thank the member for her two supplementary questions. Indeed, as I noted, when we did the last study, there was strong feedback from the industry regarding the significant business costs. But actually, in addition to that, I've also mentioned that this really is not just about cost. It goes beyond cost, because at the ground, really, there are significant, real, practical and operational challenges on top of just cost consideration. But having said that, if we were to estimate the additional cost as a result of prohibiting the transport of workers in lorries and goods vehicles, then we'll need to have an understanding of the options that the industry will pivot to, whether it's buses, minivans, goods passenger vehicles, or even other options. And we will need to really undertake a detailed study and consultation with the industry. So it is something that we can consider as part of the review. With regards to practices, international practices, as I've also said in my reply, international practices are varied. And indeed, some of these countries that do allow, we think that, it's also, our challenges are not unique and they probably have similar challenges. But I agree that even as we undertake a review, we'll consult the stakeholders in industries, and we'll also look at various practices as well as technologies like the member earlier, Mr. Alex Yam said.
Mr. Murali Pillai.
Mr. Deputy Speaker, sir, I'm glad to note from the Honourable Senior Minister of State's speech that the government is looking at the safety of migrant workers being transported in mini lorries very seriously. The Honourable Senior Minister of State mentioned about projects being delayed, in the course of this pandemic, and there's a sense out there in public, rightly or wrongly, that construction projects are being hurried to catch up with lost time. May I ask the Honourable Senior Minister of State what can be done in partnership with MOM to emphasize the safety message with the construction companies as well as the drivers? Thank you.
Thank the member for his question and for highlighting the fact that we need to continue to step up our outreach and engagement to the companies as well as to the drivers. So TP, for instance, actually have regular safety talks to the drivers to raise road safety awareness as well as to adopt safe driving habits. And we will need to continue to work together, LTA together with TP and MOM, to reach out, step up public education, sustain public education, and to outreach to them, to remind them to comply. For instance, the companies to comply with the rules and the safety rules and requirements that have already been put in place for worker safety, and to remind drivers of their obligations and responsibilities when ferrying workers.
Dr. Lim Wee Kiat, next question, please.
Sir, may I have your permission to take questions 37 to 40 together?
Please do.
Thank you. In 2020, about 200,000 tons of disposables, such as carrier bags and takeaway containers, were thrown away in Singapore, sufficient to fill 400 Olympic-sized swimming pools. Excessive consumption of disposables is unsustainable and can be avoided if all stakeholders work together to change mindsets, habits, and behaviors. Implementing a charge for single-use carrier bags at supermarkets is one of the recommendations submitted by the Citizens Work Group on reducing the excessive consumption of disposables to change social behavior. Many jurisdictions overseas have already implemented disposable carrier bag charges with positive results. For example, bag charges in jurisdictions such as Hong Kong, Ireland, and the United Kingdom, as well as Taiwan and the Netherlands, have reduced consumption of disposable bags by about 60 to 90%. A disposable carrier bag charge is not new to Singapore. As part of the Plastic Action Business Initiative started by the Worldwide Fund for Nature, or WWF Singapore, retailers such as Uniqlo, Watsons, H&M, and The Body Shop have committed to a bag charge and collectively achieved over 60% reduction in single-use bags. NTUC FairPrice has also piloted bag charges and received positive response. Last year, their year-long No Plastic Bag initiative at 25 supermarkets and convenience stores resulted in more than 15 million plastic bags saved. In developing an appropriate model for a disposable carrier bag charge at supermarkets, the National Environment Agency will study overseas examples and consult key stakeholders and members of the public. For example, the amount to be charged, whether the charge will apply per transaction or per bag from the first or third bag, implementation timeline, and how the charge proceeds will be used. We will take into account our local context, such as the current practice of reusing disposable carrier bags to bag rubbish for disposal. We will also look into any possible impact of a charge, especially on the more vulnerable groups, such as low-income households, and will consult the Ministry of Social and Family Development and Social Service agencies on the possible mitigation measures to address the impact. We will also consult supermarket operators on other details, such as how the charge could apply to home deliveries and training supermarket employees, including those who pack groceries for deliveries, to minimize packaging use. We aim to complete our consultations by the end of the year. Plastic waste generated in Singapore is either recycled or sent to our waste-to-energy plants for incineration, and not landfilled directly. As the environmental benefits of using biodegradable plastic bags do not apply in Singapore, we have no plans to encourage their use over conventional plastic bags. Every type of packaging material results in different environmental impacts, such as carbon emissions and water consumption. Rather than substituting plastic disposables with disposables made of other materials, such as biodegradable plastics, the more sustainable approach is to reduce the excessive use of disposables altogether. The disposable carrier bag charge is intended to discourage the excessive use of disposable bags and to promote the use of reusables. However, this measure alone is not a silver bullet. We must address this issue on multiple fronts, from enhancing public education and awareness to behavioral nudges, to working with producers and retailers to use less packaging upstream. All of us must play our part to catalyze a mindset and behavioral shift towards a greener and zero-waste Singapore.
Mr. Lewis Ng. You asked for your clarification to be kept short. Thank you.
Thank you, sir. I thank SMS for the good news. Could I just ask whether we're limiting the current disposable bag charge only to supermarkets, or can we also explore other retail outlets, including the e-commerce platforms as well? Thank you.
We will only be looking into requiring a disposable bag charge in supermarkets to start with, because we need to, first of all, develop a model that is workable, and then to look into the impact and any unintended consequences before we consider if this could be expanded further. In fact, in countries like Hong Kong and Taiwan, they do take a phased approach too.
Dr. Lim Wee Kiat.
Thank you. I would like to ask whether any studies has been done to show that our households here, average households, how many plastic bags do they use per month or per year? You know, what is going to be the impact on the average household?
There was an SEC study in 2018 that is regarding the number of plastic bags that's taken out from the supermarkets, and most people frequent supermarkets, so I think in 2018 was about 820 million, which is about 146 bags per person per year.
Ms. Honey So.
Thank you, Deputy Speaker. I just have one clarification. Instead of charging of plastic bag usage, whether the Ministry has considered and explored incentivizing bring your own bag initiatives instead. Thank you.
Thank the member for her supplementary question. As I have noted, charging for disposable carrier bags in supermarkets is not a silver bullet. It is, we need to do this on multiple fronts, and indeed, actually, NEA has supported, say, Zero Waste SG, for instance, in their initiative to reach out to F&B and other retailers to incentivize people to bring their own containers, reusable containers and bags. And this is one way to also shift mindset and behavioral change. But I think we need to approach this from multiple fronts, and we have seen other countries implementing disposable carrier bag charge, as well as some of our retailers with positive response, and so we are actually working on this front now.
Next question, Dr. Tan Ye Swam.
Question 41, please.
Mr. Deputy Speaker, the Ministry of Law has previously assessed whether the names of accused persons should not be published until they are convicted. In this, we looked at the practice in other jurisdictions. Broadly speaking, there are two possible approaches. The first approach leans in favor of protecting the identity of accused persons if and until they are convicted, and some rules to grant anonymity to accused persons in specific types of cases. If you look at examples, you have the Republic of Ireland. Accused persons charged with rape offences are granted anonymity until they are convicted, unless a judge orders otherwise. In Switzerland, accused persons may be granted anonymity if the court is satisfied that they could be exposed to serious danger to life and limb or other serious prejudice. In New Zealand and Australia, where your jury trials, the court may prohibit disclosure of accused person's identity if it is satisfied that such a disclosure could create a serious risk of prejudicing a fair trial. That's one approach. The second approach is to lean in favor of just having open court proceedings and all matters are out immediately. There's no general power to the courts to grant accused persons any sort of anonymity to protect their reputations. For example, in the United Kingdom, the general position is that legal proceedings should be held in public, and there are some rules, exceptions, which restrict media reporting of some criminal cases, which prohibit the disclosure of identity of accused persons. But the primary aim of those provisions is to protect vulnerable witnesses and victims and to avoid substantial risk of prejudicing proceedings if such a risk exists. The downside in this second approach is that, of course, the reputation of accused persons is often irreparably damaged by the publicity from media coverage of an ongoing criminal trial, even if they are acquitted at the end of the day. And I think Dr. Tan's question probably arises from the trials of doctors in sex crimes, but this applies to all accused, variety of cases. Our approach has been to lean towards a UK example, but both approaches have their merits and downsides. And after assessments, we decided to keep to our approach, which means that in general, accused persons are publicly tried and the verdict is publicly announced. That also allows unidentified victims of serial offenders, for example, to come forward and seek help. But I emphasize our position on this issue is not set in concrete. We can also see the merits of shifting to some version of the first approach. So we will keep reviewing this while we are maintaining status quo. But I would say that even in the current situation, in certain circumstances, there is anonymity given if it's required in public interest. For example, sensitive information relating to national security or release of the information on the accused may lead to identification of, say, children, young persons, alleged victims of sexual or child abuse offenses. But the reason for doing that is to protect those vulnerable victims and the children from being identified and give them a better life. So on that, with that focus, the courts have some power to prohibit publication of the identity of the accused and impose some conditions on how the trial can be reported. And the media has got to comply with those requirements. There are, as I said, pros and cons with both approach, whether to allow or to prohibit the publication of names of accused persons until they are convicted. And as I said earlier, we will keep our position under review. Thank you, sir.
Order. End of question time. Ministerial Statement. Minister for Communications and Information.
Thank you, Mr. Deputy Speaker. Sir, last Thursday, Singapore Press Holdings Limited, SPH for short, announced its proposal to restructure and transfer its media business to a company limited by guarantee, CLG, to secure its long-term viability. My ministry has voiced the government's support for SPH's proposal and committed to support the media business as it builds capabilities and adapts for a digital future. Today, I will bring members through the key considerations behind these decisions. First, the importance of local news media to our nation and how we have upheld it through our history. Second, the government's reasons for supporting SPH's proposals. And third, our commitment to help our local news media adapt and thrive in the digital era. Mr. Speaker, sir, a high-quality, professional, and respected media reporting news by Singaporeans for Singaporeans is essential to the fabric of our nation. Our local media is keenly attuned to our unique circumstances as a small city-state, an open economy, and a multiracial society. They help interpret global events through a distinctively Singaporean lens, analyzing their impact on our lives. This is ever more crucial in an era of heightened geopolitical contestation. The local media also express our identity, values, and priorities so that the world gets a perspective from Singapore itself and not through the filter of others. Domestically, the local media not only reports on events and developments, but also publish a balanced range of views to inform the national debate and help foster a national consensus, not allowing disagreements to deepen into divisions in our society. They help to sustain the common ground in our multiracial and multireligious society, whilst preserving the voice of each of our communities through the vernacular media. And they write the first draft of our history, as Mr. Goh Chok Tong put it in 1995, serving as an authoritative record of our collective experience as a people, giving future generations of Singaporeans a sense of how we saw the world, what was important to us,
and how we build tomorrow's Singapore. The local news media fulfill this role while upholding high standards of accuracy, objectivity, and balance. These are traits that are ever more scarce in the raucous global information landscape, especially online. The local media help to distinguish fact from falsehood, substance from posture, what is high from what is low, as Mr. Lee Kuan Yew put it in 1998. As our nation faces increasingly complex challenges and trade-offs, our local media provide a highly credible flow of information and analysis upon which we form collective decisions. COVID-19 vividly exemplified this. In the pandemic, Singaporeans looked to our local newspapers and channels as their trusted sources of critical information. In a 2020 survey by the British pollster YouGov, 7 in 10 Singaporeans said they trusted the local media's reporting on COVID-19. In the UK, by comparison, YouGov found that only 3 in 10 trusted the information on COVID in British newspapers. In 2021, the Edelman Trust Barometer reported Singaporeans' trust in local media at 62%, above the global average of 51% and above the US number, which was 45%, and UK and France, which were both at 37%. It is critical to maintain this trust. Our local media industry has strived to do so while adapting to changing industry trends and commercial imperatives. Because of its importance to the national interests, the government has been an active steward in this evolutionary process to ensure the vitality and viability of our local media industry. Let me cite 2 examples. In 1984, SPH was formed through a merger of the English, Chinese, and Malay language papers, with the Tamil press brought under its umbrella later in 1995. The primary aim of this merger, nearly 4 decades ago, was to preserve the vernacular media. The government could see that the vernacular papers would come under greater financial pressure over the years with the gradual shift towards English. As Mr. Lee Kuan Yew explained at Nyan He Tsaopao's 80th anniversary in 2003, my worry as Prime Minister was how to preserve at least one quality Chinese newspaper and sustain it over the long term when the trend in education was towards English. The merger reduced duplication of overheads and costs of competition and enabled the SPH newspapers to achieve economies of scale and greater commercial viability. Between 2000 and 2005, the print and broadcast industries launched into more direct competition, but subsequently reconsolidated. Initially, SPH and MediaCorp were allowed to enter each other's main businesses, with the trend towards convergence between print and broadcast. The hope was that greater competition between them would spur both to develop better local content and retain local audiences against rising foreign competition. The competition was fierce, but ultimately the model did not prove to be viable. Against the backdrop of the dot-com crash and SARS, the industry was rationalized in 2004 to preserve the viability of the 2 companies. One, a core broadcaster, and the other, a core newspaper group. So today, yet again, our local news media is at a watershed. Sweeping structural changes in the media and advertising industries caused by technological advances and the internet have severely disrupted the traditional business model that relied on print advertising revenue. The competition for eyeballs has intensified. In the borderless online space, our local news media must now compete not just with international news organizations, but also entertainment providers and user-generated content. The cost of producing quality news content remains high, but revenues have plummeted. Global print advertising revenue is decreasing by 7% year on year. Meanwhile, news aggregators and other news providers are now able to provide so-called free news services without the cost of maintaining a high-quality newsroom. Though digital ads are growing, it is the digital platforms like social media and search engines that capture the lion's share of the revenue. Though the demand for quality news has not diminished, monetizing digital initiatives is challenging, and the revenues of quality news platforms all over the world are falling sharply with little prospect of relief. Just last week, on World Press Freedom Day, the Executive Director of the World Association of News Publishers, Andrew Heslop, published an article quite aptly titled, "Media Across the Globe, Fighting Immediate and Existential Threats." And he warned, many of the difficult questions facing the news industry are underpinned by an inability to predict a general economic model that will guarantee a future for quality professional journalism. The harsh reality, public interest reporting simply does not convert to advertising dollars. For many media companies, the economic fallout of COVID-19 was the final straw. An article in the Columbia Journalism Review described it as the journalism crisis across the world. Most publications are now running deficits, and many newsrooms are shrinking, even closing. More than a quarter of American newspapers have disappeared in the last 15 years, reducing the number of newsroom jobs by half. In the UK, more than half the country is no longer served by their own local newspapers. Southeast Asia has seen well-known newspapers change hands, restructure, or shut down in recent years. The Jakarta Globe ceased printing and went fully online in 2015, and the Philippine Star had a majority stake acquired by the telecommunications group PLDT. Ours is a small local market with just two main local news media organizations, SPH and MediaCorp. While there are potential synergies and opportunities for collaboration between them, we can ill afford the convulsions and closures we have seen elsewhere, with a consequential loss of diversity and choice in our media landscape. The response of media companies across the world has been varied, reflecting their own social and political context. Many have resorted to cost-cutting to survive. News Corp, one of the largest media groups in the world, recorded a $1.5 billion loss in 2020. It is now embarking on a consolidation exercise, which will likely entail major cost cuts and job losses. Even digital news sites, which have ridden the wave of internet media, have not been spared. Popular site BuzzFeed, which claimed a greater online audience than the print circulation of any single newspaper, has never made a profit and was compelled to abort its global expansion plans last year. Some publications have received life support from wealthy financial backers or funds. Billionaires have acquired established newspapers for philanthropic or other motivations. The Washington Post was bought by Jeff Bezos of Amazon in 2013, after 80 years of ownership by the Graham family, which had sustained the paper partly on the proceeds of its Kaplan education business. In the 6 years before the sale, the paper's operating revenue fell by 44%. The South China Morning Post was owned by Rupert Murdoch's News Corp until 1993, when it was acquired by Malaysian real estate tycoon Robert Kwok. In 2016, it was acquired by the Alibaba Group. With the largesse of Alibaba, SCMP lifted the paywall on its articles and was reported to have increased its international reach more than fourfold within 3 years. Yet it remained loss-making. In 2020, SCMP restored the paywall and subscription model, acknowledging that the advertising model is no longer enough to sustain high-quality news. Other major newspapers now owned by billionaires include the Los Angeles Times. Even hedge funds have got into the act. Alden Global Capital acquired over 200 US newspapers with extensive layoffs and cost-cutting measures. Some newspapers have received funding from non-profit organizations. The Guardian in the UK has been owned by the Scott Trust since 1936. It has done well against global competition. Nearly two-thirds of its readers come from outside the UK. But in 2020, after making a £25 million loss even after drawing from the trust, the Guardian announced plans to cut 12% of its workforce, saying that we face unsustainable annual losses in future years unless we take decisive action. Even the rare papers that are profitable are under continuing pressure. The Wall Street Journal has had to make numerous changes to its operating model to keep afloat. While investing in a special innovation team of 150 employees, it has also had to thin out its print edition and lay off staff as recently as 2016. The New York Times has done especially well in making the digital pivot, recently reaching 7.5 million subscribers in 2020, though it too saw ad revenue plunge by 26% the same year. The New York Times' success is not easy to replicate. Beyond digital transformation, it commands a global attention that is difficult for our media, writing from the perspective of a small country, to emulate. It is also noteworthy that the New York Times and Washington Post tripled their digital subscription during the period of the Trump administration. Meanwhile, US metropolitan dailies of comparable size, like the LA Times, Chicago Tribune, and San Francisco Chronicle, have seen significant falls in circulation, in part because of subscription fatigue among readers. The Financial Times, which enjoys the advantage of being a specialist newspaper, employs rigorous data analysis to tailor its coverage and subscription offers at its target segments. It has a small but affluent readership, exemplified by FT's weekly lifestyle magazine called How to Spend It, with strong advertising appeal. Still, in 2015, the Japanese media group Nikkei bought Financial Times from Britain's Pearson. So even a successful newspaper is susceptible to takeover. Governments around the world have recognized the news media as a public good that merits direct public funding. Public funding of broadcast media is well known. Less well known is public funding of print media, but it has a long tradition in European countries. The French government spends hundreds of millions of euros annually to support the press, including prominent papers like Le Monde and Le Figaro. It has done so for over half a century, with annual subsidies at times exceeding €1 billion. Scandinavian governments too have supported their newspapers for decades, both through direct subsidies and tax breaks. In 2020 alone, the Norwegian Media Authority gave press subsidies of €43 million, while Sweden rendered a €65 million aid package to buffer the impact of the pandemic. In Singapore, we provide annual funding for public service broadcasting to Mediacorp. Last year, we also provided SPH Media with over $30 million through the National Job Support Scheme, and we were prepared to do more if the need arose. So in sum, the global news media industry is under severe structural pressure, and there is no universal solution. A few have succeeded, some are struggling, many have failed. The sources of support, be it public, private, philanthropic, or others, have varied widely. And at this critical juncture, SPH Media must similarly chart its own course to revise and, if necessary, reinvent its business model for the digital age. Against these industry headwinds, SPH has held out longer than most. In fact, SPH's overall reach and readership has never been higher. SPH Paper's total circulation has grown by 5% from 2017 to 2020. In fact, within this period, the Straits Times print and digital circulation has grown by about 20%. SPH has also made significant investments of about $50 million a year for the last 5 years to build digital capabilities and grow its readership. It has augmented newsrooms with a wider range of tech capabilities, such as product development, digital content production, data analytics, and audience development. It has modified its operations to generate content round the clock and deployed it on a wider variety of social media platforms, including Instagram and Telegram. SPH has launched new platforms for readers to engage its correspondents and experts, and has been recognized internationally for its excellent data visualization and interactive graphics, multimedia, and photojournalism. Last year, it emerged as the biggest winner at the Asian Media Awards, with the Straits Times and the Chinese Media Group picking up accolades in breaking news, infographics, feature photography, and newspaper design, to name a few. So in short, these are not news platforms that are declining in quality or readership. On the contrary, like MediaCorp in broadcasting, SPH papers continue to be trusted and valued sources of news that are well read, which is a tribute to the professionalism of our journalists. Their challenge today stems from an inability to monetize their gains in attracting and retaining readers on digital platforms. Despite rising readership, SPH's media business has been steadily losing revenue. SPH announced last week that its media business had lost half its operating revenue in the past 5 years and posted its first ever loss of $11.4 million in 2020. And that loss would have been deeper without the government's JSS grant. Looking ahead, SPH expects these trends to persist and widen. Print advertising revenue will continue falling as media consumption progressively shifts online. Rising digital advertising revenue will not compensate for the fall in print advertising revenue. And there is limited scope to grow digital subscriptions given our small domestic market and the global competition. These secular trends are undeniable. They affect SPH, MediaCorp, and the global media industry. And the adverse effects will be compounded by the lingering economic impact of COVID-19, with businesses cutting ad spending and consumers reluctant to pay for content. SPH has been under persistent pressure to account to shareholders for the anemic financial performance of its media business. Hence, the company has implemented several cost-cutting and retrenchment exercises in recent years. But SPH has assessed that any further cuts would impair its ability to maintain quality journalism. SPH has also spoken of its constraints as a listed company to make significant and sustained investments in their digital and newsroom capabilities, which may not yield near-term payoffs. Hence, under the current structure, there is a serious risk that SPH's media capabilities will be hollowed out. Without sustained investment in capacity building and a digital pivot, its quality and circulation will fall, and this in turn will worsen financials and cause further disinvestment. And the immediate pressure will inevitably be on our vernacular papers, some with relatively small circulations, which would have a profound detrimental impact on the multiracial fabric of our society. Mr. Speaker, sir, this is the sobering picture of what lies ahead if we fail to act now and take proactive steps. Without a responsible and high-quality local media, the quality of our public debate and discourse will be compromised, and we will slowly but inexorably become less cohesive as a society. Given what is at stake, the government must take a long-term view and adopt measures to secure the sustainability of our local media. The government, therefore, carefully studied the proposal from SPH. SPH proposes to restructure and transfer the ownership of its media business to a company limited by guarantee. It will first form a new subsidiary, transfer the media-related businesses and properties to the subsidiary, and capitalize the subsidiary with $80 million of cash and $30 million worth of SPH shares and REITs. Subsequently, if SPH shareholders give their approval, this subsidiary will be transferred to the CLG. The CLG will be separate from the listed company, no longer run by the SPH management. It will operate as a revenue-seeking business subject to the usual commercial disciplines. However, any operating surplus will be plowed back into the media business rather than distributed to shareholders as dividends. In that sense, it will be not for profit to the members of the CLG. This concept of a CLG run with commercial discipline is not new for us. There are several examples, including our universities, the Esplanade, and Gardens by the Bay. SPH's proposal is not a panacea for the challenges faced by its news media business, but it is an essential first step if the media business is to adapt to the digital and commercial realities of the industry. The government, therefore, supports SPH's restructuring proposal and is willing to provide funding support to the CLG. Let me summarize our thinking. So, a high-quality and trusted national media with an instinctive understanding of our national interests and constraints is essential to Singapore. Throughout our history, the government has aimed to develop and sustain such a media industry in Singapore. However, the current SPH model of a news media business within a listed company is no longer viable. While the media business's traditional revenue streams are declining sharply, significant investments are needed to build digital and other capabilities for the longer term. A company limited by guarantee is one model to remove the news media business from the constraints of a listed company, while the news business under the CLG invests in strategic imperatives. But the CLG will still have to find new sources of funding to meet the expected financial shortfalls in the news business. The government is willing to help fund the proposed CLG while ensuring fiscal discipline and accountability in areas like digital innovation and capability development as part of a long-term sustainable business plan. We already have a similar financing model with MediaCorp, our core national broadcaster, which has been working well. Having such national broadcasters, newspaper publishers, and online news platforms is a public good that benefits the whole of society. Although the business and financing model will change, the government does not intend nor expect this to affect the relationship between MCI and the SPH newsroom. The government is mindful that our local news media must remain credible institutions that are trusted by Singaporeans and that it remains the responsibility of the editors and journalists in SPH media to report news and diverse opinions objectively and from a Singaporean point of view. So, looking ahead, the CLG's success will be determined by three key factors. First, strong leadership with the support of its stakeholders to set the strategic vision and execute the organizational transformation. Second, a robust business strategy that can be sustained under the new structure with the requisite resources. Third, a strong and capable team of professionals in the newsrooms who will maintain the high standards that we have come to expect of this cherished national news organization. In this regard, the Newspaper and Printing Presses Act, Nppa, is a key regulatory instrument that will apply to the new entities, the news entities, under the CLG. The Nppa was introduced in 1974. It places restrictions on the ownership and control of local newspaper companies. Among other requirements, newspaper companies like SPH are required to issue two classes of shares, ordinary shares and management shares. Ordinary shareholders can each hold no more than 5% of the company's shares, except with the approval of the minister. This prevents excessive influence over local newspapers from any single source, local or foreign. Management shareholders have special voting rights on resolutions relating to the appointment of directors and staff of the newspaper company. The issuance of management shares and the appointment of directors must be approved by the minister. The intent has always been for these management shares to be held by reputable and established institutions, so that the stewardship of the newspaper is entrusted to entities with an abiding interest in and commitment to Singapore's stability and success. Currently, the management shareholders of SPH are OCBC, Great Eastern, UOB, DBS, Singtel, NTUC Income, Temasek via Fullerton Private Limited, NUS, and NTU. As SPH restructures its media operations, we want to ensure that its management shareholders continue serving as custodians of the CLG. I have therefore met and consulted the representatives of the management shareholders, and they have all agreed to form the CLG and to be its founding members. This will ensure that our local news media will remain in the hands of trusted institutions with a long-term stake in Singapore. In due course, the membership will be expanded to include newer and more diverse institutions, such as institutions as stakeholders of the CLG. One important and immediate decision for the CLG is the appointment of the chairman of its board. I also discussed this with the management shareholders. They have all agreed that given the national importance of this undertaking and the scale of the challenge, the chairman should be Mr. Khaw Boon Wan. With his high standing and more than 25 years of public service experience in various senior appointments, Mr. Khaw will be able to provide strong strategic leadership for the CLG. And I'm pleased to inform members that Mr. Khaw has agreed to be the chairman of the CLG, and he will be sharing his thoughts on its way forward in due course. To ensure the long-term viability of the enterprise, the government also stands ready to provide the CLG with funding in areas like digital innovation and capability development. We want to ensure the CLG has the wherewithal to innovate, build digital and other essential capabilities, and confidently take on new challenges. The new media company must have a long-term, sustainable business model with different revenue sources, including traditional advertising and subscription revenues, complemented by government funding and contributions from its management shareholders and benefactors as other components. We expect that after the transfer of the media business, the CLG will formulate detailed proposals on its strategic plan to build the business, and this will form the basis for government funding and support. On the regulatory front, the government will maintain the safeguards hitherto placed on the media business under the Nppa. Subject to shareholder approval, after the restructuring is completed and the media business is transferred to the CLG, MCI will lift the shareholding controls imposed on the listed SPH entity. The Nppa will then apply to the new media company under the CLG's charge. The Nppa will not apply to the CLG, but appropriate safeguards will be incorporated in the constitution of the CLG to ensure that the CLG structure achieves its purpose and fosters the objectives of the Nppa framework, and that its members and directors will remain committed to Singapore's stability and success. Mr. Speaker, sir, we want the news media business to succeed in this critical transition while continuing to fulfill its vital role in our society. As I said at the beginning of this statement, a high-quality professional and trusted media with news reported by Singaporeans for Singaporeans is essential to the fabric of our nation. That mission statement remains unchanged. Within the framework of the Nppa, the local media operate independently of the government. They report and analyze the news fully and objectively, not holding back bad news nor advancing any singular ideological view or agenda, but focused on Singapore's interests. The government and the media will not see eye to eye on every issue and incident, but that is to be expected. And that is how SPH and MediaCorp have operated hitherto, and that is how the government expects the CLG to continue to operate after the proposed restructuring. The CLG must maintain the reputation and high level of trust that SPH has built with generations of readers domestically and internationally. Mr. Speaker, the restructuring of SPH is a watershed in the evolution of our local news media. But we are convinced that it is essential if our news media are to survive as high-quality news outlets. And the government will do our part to sustain a trusted news media in Singapore. Sir, our news media are not just economic entities. They are cherished institutions that reflect our values, whose past, present, and future are intrinsically tied to this nation, as Prime Minister Lee put it at the Straits Times' 170th anniversary. The newsrooms are and must continue to be home to talented editors and journalists whose professionalism and diligence have built credibility and trust in our newspapers. As 19-year-old A-level graduate Keng Sin Yi said in today's Straits Times, and I quote, "It is important to keep SPH media alive and motivated to produce quality newspapers every day. ST has been serving Singaporeans with diligence and high standards, educating us from the time when we knew little about the world. I hope we can express our gratitude by supporting and respecting these dedicated journalists. Together, we can keep our source of knowledge going and keep our ST alive. I want ST to be a part of the lives of my future children and grandchildren too." Sir, the success of this restructuring and the future of our local news media turns ultimately on our journalists' commitment to this mission and the support of our citizens like Sinyi. And I would like to conclude by assuring our journalists and all Singaporeans of this government's abiding support for this critical national endeavour.
Mr. Pritam Singh.
Thank you, Deputy Speaker. I have a few clarifications for Minister before that. I'd like to thank him for his statement, which a lot of information, or some information at least, the public has heard for the first time today and here in the House. I have a few questions. First, when the government first informed SPH that it was prepared to extend grants to support its media business? Secondly, what is the size of the funding the government has penciled yearly to support the SPH CLG? Does the government aim to cap the grants it extends with the expectation that the CLG would also secure other sources of funding from the private sector, for example? The third question is, this is with respect to some public documents that were released by SPH last week. It was decided that the SPH contribution towards the CLG would be, was, I quote, arrived at after considering various factors, including the potential funding requirements of the media business for a few years, unquote. Does the ministry consider this contribution to be a reasonable one? And how did it come to this conclusion? My final two questions, what structures will the government insist on to ensure the independence of the SPH-CLG from possible government interference, to foster a culture of editorial and to foster a culture of editorial independence across its titles? And finally, in view of the significant change in this sector, would the government consider the formation of a select committee to allow members of the public and Singaporeans in particular to A, express what editorial standards they expect from the CLG taxpayer-funded mainstream media, and B, to express their views on how best the SPH CLG can ensure editorial independence from any government of the day? Thank you.
Minister.
So I thank the Leader of the Opposition for his series of questions. They span a wide range of issues. I will attempt to give him a comprehensive response, but I imagine this is going to be further developed in subsequent clarifications. First, on the issue of timing, about when did we inform SPH that we're willing to fund SPH, I think, as I said in my statement, the government has always taken the position that we are willing to support investments in capability development, and then it is up to the respective organizations to develop their plan and to put forward their proposals to us. In the case of SPH specifically, as I mentioned, last year they received the JSS, which was part of the national scheme. In addition, we were prepared to offer extra help if it was required, but the restructuring proposal was put to us, which then leads to the next question about other sources of funding and whether government funding to the CLG will be capped. Mr. Speaker, I would say, Mr. Deputy Speaker, I would say that it's premature to specify the exact numbers that will go in regard to the government funding. And the reason for this is not because we are reluctant to talk about them, but it's simply because, first, this is still a matter before the shareholders of SPH. They have to decide whether they want to approve this. It is only after that that we can really get into a more detailed discussion. But it's not just about the shareholders' approval. We also need the new CLG to then formulate its plans and put on the table what it sees as its strategic business direction going forward. And in that matrix, the different sources of revenues that it expects or anticipates, and what role will the government funding be or play in that matrix. So the question of whether other sources of funding will be required, I think if the Leader of the Opposition had heard earlier from my speech, not-for-profit does not mean that the entity does not pursue its business on a commercial basis. And we fully expect the entity to seek out advertising revenue, circulation or subscription revenue, and other sources of funding. But we fully expect that government funding will be a component of that funding matrix for the CLG. He asked if the SPH contribution, which has been spelled out, which includes the transfer of 2 property assets which are related to the media business, and also some other operating businesses which are linked to the media, in addition to the $80 million of cash and $30 million of SPH shares and REITs. And he asked whether this is reasonable and why. Again, Mr. Deputy Speaker, I want to stress that because this is a matter that has to be put to the shareholders at an EGM, I do not want to preempt any case that the management and the board will make. But I can say that our focus, the government's focus, has been very clearly on the news media business and its viability going forward. Whilst I'm unable to say specifics about what the numbers look like in the near term, SPH has said some about how they think it will continue to widen in terms of its deficit. I can say that the medium to long-term outlook remains challenging, and that is why we need to be clear that government will be prepared to come in to give support. But how much, how, I think these are the things that will need to be worked out in due course after the CLG has had a chance, subject to shareholder approval, to then develop a business plan and put the proposal to us. The member asked about structures for editorial independence or ensuring a culture of editorial independence. I would venture that that culture already exists in Singapore, in the news media. And I think we do a disservice to our journalists and editors to suggest anything to the contrary. And in fact, if you look at the overall outcome that we have achieved over the years, it speaks to, not just from external sources that validate by recognizing the accomplishments of our local news media, but importantly, and this has a bearing on the Leader of the Opposition's last point on a select committee, because if I understand correctly, it's about enabling people to express their views. I would say Singaporeans have already expressed their views because, first, when it comes to trust surveys, Singapore scores highly. Singaporeans have been quick to point out that they trust our news media, both print and broadcast, and they've shared this, and I cited the YouGov survey and also the Edelman Trust report. I would add that even our local surveys, for example, by the IPS, validate this, saying that about 70% of Singaporeans, or 7 out of 10, trust our local media. And that is at a higher level than the trust they accord international media, I would add. So it's not just what they say, though, it's also what they are doing. What are their habits? What are their preferences? In other words, how are they voting with, in this case, their eyeballs? And the fact is, as I said, and I want to re-emphasize, the SPH news organizations in aggregate have not just maintained, but they have grown their reach and readership when you combine the digital and the physical. That would not be the case if Singaporeans did not feel that they could trust the news organization. So I think the people have spoken, and I think it's our job now to make sure the object of their trust continues to succeed.
Mr. Darrell David.
I have a couple of supplementary questions for the Minister. First of all, Minister, the government does provide funding to the new entity, the new CLG called SPH Media. I think it's reasonable if you provide the funding to have some expectations, to have some accountability, to have even some conditions. Can Minister perhaps develop on what are some of the accountabilities or even the KPIs that the government will expect from the new CLG in return for the funding? And of course, with that accountability, with that expectation, there could also be the criticism that therefore that's a way also of exerting control over the CLG. Could Minister perhaps also expound on some measures that could be put in place to balance off between expecting accountability, but yet at the same time having a hands-off approach and not necessarily shaping or influencing how the CLG would then do its business? Thank you, Minister.
So, Deputy Speaker, I thank the member for his questions. First, on accountability and conditions or KPIs tied to the funding. Again, I want to start by saying this is still a matter that has to be approved by the shareholders of SPH before we can start talking about these matters in greater detail. But I can talk about it in terms of broad principles. Clearly, and as I said in my ministerial statement, we want to do this, and by this I mean the funding of the CLG, with financial discipline and accountability in areas like digital innovation and capability development. And what does that mean? It means that if the funding is given for a specific purpose, then the expectation is, and in this case it's about building capabilities, for example, then the expectation must be that those capabilities are indeed developed. But it goes beyond that, because the development of capabilities in the end is a means to a more important end. And that end is sustaining, if not growing, the attention, the readership, and the following from Singaporeans. It is something that both MediaCorp and ST have been doing, the SPH news groups have been doing with significant success over the years, but clearly it is something that we will want them to continue to strive to achieve. Because at the end of the day, if you do not have the eyeballs, the attention of people, then the effort, in a sense, will ring hollow. And our objective, when we talk about a trusted, professional, high-quality news organizations, the ultimate measure of it, as I said in my response to the Leader of the Opposition, is in how our citizens respond to it and how much attention they give it, whether it's in terms of readership, dwell time, and this is especially so in a moment of crisis, which is when the truth and reliability of information becomes even more critical. On the point about control, I think I had said some of this in my earlier response, but perhaps I could I think first, let me acknowledge that it is inevitable that whenever you have a change, in this case, structural change in the organization, such concerns will naturally arise. It is inevitable and it's quite understandable. But I think as we deliberate on this and we discuss this in this chamber, we also need to keep in mind, where are we starting from when thinking about the future? We are starting from a position where we have two news organizations, media organizations, one a core newspaper group with radio and online presence, another a core broadcaster with radio and online presence. So some overlap, but distinct core competencies. And these organizations have developed under our existing model. And what I mean by that is SPH is subject to the Nppa and the restrictions that go with it. MediaCorp gets funding from the government in the form of public service broadcasting. And in both cases, they have been able to pursue their editorial policy in a manner that has allowed them to win the trust of Singaporeans, as evinced by the various studies and surveys and so on, and also the reading habits of Singaporeans. So, if I may put it another way, if it ain't broke, don't fix it. So we have something that is working. The part that is challenging is the financial model in particular. We need the business must be given enough time to be able to transition to a more sustainable business model. And that is something that we are now committed to do by rendering support to the CLG, but without changing the nature of the relationship that we have today between these news organizations and the government and MCI.
Ms. Jessica Tan.
Thank you, Mr. Deputy Speaker. I have two clarifications for Minister. Minister, you spoke about the impact of digital disruptions on the news media industry, and while digital investments and funding are important to maintain quality local news media, this clearly is not enough. In fact, SPH has actually grown its digital footprint as well as its viewership. The challenge has been viability. So what will be different for the CLG to achieve the digital pivot, as Minister has said is required? A clear strategy to transform and to drive digital innovation is required. And how will this new entity achieve that? My second question is a different one, but an important one to maintaining the core of the quality of local journalism, and that is really its people. And in this case, it's the journalists themselves, as well as the experienced team that produce the content. So what is being done to ensure that this retention of talent is there, as well as, more importantly, the ability for the new entity to attract new talent required to do the pivots it requires?
So, Deputy Speaker, I thank the member for her questions, which are both, I think, very important. Perhaps I start with the people question first. One cannot talk about quality journalism without talking about quality journalists. It's indivisible, and indeed, when we talk about investing in the capability of our news media, this is one of the key attributes. The ability to attract, retain, and develop talent, journalistic talent, which can take our news media industry forward, both for the quality of its news reporting and also for its analysis of global events, local events, and to be able to offer that distinctly Singapore perspective, which we need for all the reasons I've outlined. So we are very clear that when it comes to the people element, it is something that must continue to be supported. How that is done is a matter that the company itself must take forward. And what I mean by this is that, so for example, if we think back to the job support scheme, the objective was very simple, to prevent attrition of capabilities that have been developed and that are needed for the future. But what we need, I think, in the context of SPH now is not just the prevention of attrition, but actually the ability to build on that capability, which I think is the point that the member makes as well. And so I think this is an area which the new CLG chairman, the board and the management will be seized with. And I would imagine as part of their strategic business review, the human dimension is going to be key, because ultimately that is what sustains the news media. Having said that, the earlier point about what will be different, and I agree with the member, financial support or money alone is not enough. I think really it's about what you are using these resources for, and therefore what will be different. As I pointed out, I think the current structure, whilst there has been a considerable effort on the part of SPH to pivot to digital, and they've made the investments I've mentioned, about $50 million a year over 5 years. But really, they need to do more, and they need to do it in a more purposeful and quick way. I think that is something that if you talk to the editors and the journalists, they will say, and that is also the experience that we see around the world. So therefore, I think first, the fact that you are now moving out of a listco structure into a CLG model will give the company the opportunity to dedicate the resources it needs for this purpose. And that is where I think the support from government will also be important. And I would say that the other thing is, in terms of again, I think the point that the member makes, and the member would be very familiar with this, it's not just about tech, it's about how that tech is applied in the context of this vertical and how it is used to deliver a product that is valued by the customers, the readers, and whether there are different ways to find new revenue sources arising from that. So this is a very important area of work. I know that within the current SPH system, they've put some degree of effort into it. But going forward, I think the CLG and the management will have to bring in talent in addition to what they already have within to address this in a very direct way and start making the decisive strategic moves in that regard. So I think the ability to make such moves and then back them with the resources and then find the talent to back it up, these are all going to be important differentiating factors in the change that that's being proposed under the restructuring.
Mr. Liang Eng Hua.
Thank you, Mr. Deputy Speaker, sir. So we understand the severe commercial challenges faced by SPH Media as a standalone entity, as a listco, and would require government funding to support, to put them on a more sustainable path. So I have two clarifications for ministers. Firstly, how did the government arrive at the decision that the CLG structure is the best option? And second clarification is, have the government considered other options, such as privatizing SPH, so that the media unit is not subjected to the market returns pressure, very much like the SMRT, or even the Media Corp approach where the government support the company with annual public service broadcast grants.
So, Deputy Speaker, I thank the member for his questions. How do we arrive at the CLG structure and were alternatives considered? First, we have to be very clear how the proposal came about. This is the result of SPH management and board assessing their business, in particular the media business and its prospects going forward, and then putting forward a proposal which in their assessment achieves best the objective of ensuring the viability and success of the media business going forward, freed from the constraints of a listed company and its reporting structures and so on. So that's how it came about. And this, I want to emphasize again, is a proposal that awaits shareholder approval. So I do not want to go into a detailed discussion on its merits, but as I have said quite clearly, the government supports it. We're supporting it not because of the shareholder value proposition, that is for SPH and its management and its directors and independent financial advisor and independent directors to explain to their shareholders. We support it from the perspective of what needs to be done to secure the long-term sustainability of a quality, trusted news media in Singapore. That's the focus. So other ideas, whether it's privatization and other formulations, I think these are questions that I'm sure the board and management would have considered. But I also want to point out that from the government's point of view, the regulatory levers are quite specific. They only pertain to decisions that affect the news media business in the way I've explained. So I think the larger issues around the business, its viability, its decisions on what can be done for shareholder value, ultimately is something that the board and management have to decide on and propose to shareholders to agree. Then I think the member asked the question, is it possible for us to support the company in this present form, I assume, with something like public service broadcasting funding and so on? Can it be considered? I think the answer is obviously yes. But is that a good model? I think that's debatable. Why is that debatable? Because I understand the intent of the member. In other words, the business is within the ListCo, it is having some challenges. Can we just direct the funding to that operation in that business for it to succeed? The problem is, if we channel a certain amount of funding to the listed company, and the listed company then makes profits, and then it distributes dividends to its shareholders, the question that then can be asked is this a case of taxpayers subsidizing returns to shareholders? So there is an issue there. And so then it means, do we need to find other constructs to deal with it? And I don't want to labor the point, but other than to say that I don't think it is a straightforward solution. I think it is fraught in its own way. So what we have before us is the proposal that the board and management of SPH put to us after their own deliberations of various possibilities. Our lens is purely from the point of view of how do we ensure a quality, professional, trusted news media continues to succeed in Singapore. And that's the basis on which we have expressed our approval for the restructuring.
Ms. Sylvia Lim.
Thank you, Mr. Deputy Speaker. First, I'd like to say that I welcome Minister's statements in his speech that the government and SPH media will not see eye to eye on matters, and it is as it should be if the newspapers are to be credible to readers. I welcome that statement strongly. At the same time, he has acknowledged that due to the proposed change in the funding, there are some concerns about the implications of government funding on the editorial direction of the newspaper. And in the same breath, he just announced to us today that the government and the management shareholders of SPH have agreed on the choice of the chair of the CLG to be Mr. Korbenwan. I have some clarifications on this choice. First, let me clarify that I'm not questioning the personal integrity of Mr. Kor, but the fact is that he is the former chairman of the People's Action Party and former coordinating minister for infrastructure. So I'd like to ask Minister, first of all, the choice of Mr. Kor, although he said it was by agreement between the government and the management shareholders, am I to assume that it was the government's suggestion that Mr. Kor take on this role and the management shareholders agreed to that suggestion? Second question, does Minister not see this as a missed opportunity in the light of the major restructure that is coming up and some concerns about what this would mean for newspaper content? Is this not a missed opportunity where someone else who is not so closely linked to the government could have been chosen to be the chair? Were any other candidates considered? Thank you.
So, Deputy Speaker, I thank the member for her clarifications. Let me just be very clear. I said in my statement that the news media and the government will not always see eye to eye. I don't think the definition of a good news media or a credible news media is that it must always not see eye to eye, but it has the occasion when it's necessary to be able to do so. So I want to be clear about that. Second, I think the nub of the question really is that with Mr. Korbenwan being asked by the management shareholders to chair the CLG, whether this creates problems from the point of view of editorial independence. I presume that's your main point. And let me put this in a very, I think let's start with where we are today. SPH's current chairman is Dr. Lee Boon Yang, and he is a former cabinet minister. In SPH's history, they have had other chairpersons who have either been ex-senior civil servants or ex-cabinet ministers. MediaCorp's chairman today is an ex-senior civil servant. And yet, we are where we are today, and I do not wish to canvass the arguments all over again, but we are where we are today in terms of the credibility of our media, the trust that Singaporeans have in our media, through this array of leadership. And I think we should therefore be very clear that what matters is not a perceived political hue in the appointments, but rather in the substance of the character and capability of the people who are involved. And I think in that regard, Mr. Korbenwan, I think, will be, he's held in high standing in Singapore by many and so beyond Singapore. And he has a proven track record of taking on difficult issues and working on them. And this is one such issue. And what you need is someone at the leadership level who has the gravitas, has the strategic vision, and the experience in undertaking these sorts of major tasks. And make no mistake about it, this is a major undertaking, and it is one that is of national importance. So I think the choice of Mr. Khaw Boon Wan is something that not just the government, but in fact the management shareholders were very keen on. And as I said, it was a discussion that we had. This is not the kind of position for which you have a very long shortlist, or that would do a global search, In the end, you have to decide on the basis of what is needed, what are the attributes we seek, and how do we go forward. And that's what happened here. And I think, therefore, is this a missed opportunity? I think what would be a missed opportunity is if we allow political considerations to prevent us from making the right decision in terms of the right person for the job to get it done. And I think that's what we have sought to do.
Ms. Mariam Jafar.
Mr. Deputy Speaker, as a consultant in the area of technology, media and telecommunications, I want to say that the proposed transfer to a non-profit structure for SPH away from the glare of investor expectations seems to make sense and will give the SPH group more time to fundamentally transform. But as said by Minister, it's no panacea. I have two clarifications to ask of the Minister, building on some of the questions earlier raised by the member Jessica Tan. First, how will SPH Media Group maximize this opportunity for a fresh start? Which means essentially answering the question, what can we sell that is insightful, relevant, and distinctive, and provides an engaging audience experience? To whom and at what price? Which will likely have to be consumer pay, because advertising is not going to cut it. The fundamental source of competitive advantage here has become distribution, and has moved to the digital giants. And with what technology to support all this? And how can you operate at a drastically lower level of cost in order to make money? Including, for example, by moving to much more greenfield tech platforms. I recognize these are questions for the CLG, really. But I think what I would like to know is there an ambition within the CLG to think of SPH Media Group now more as a startup to benefit from this fresh start rather than incremental thinking? How will the new entity be able to attract a visionary CEO in addition to talented journalists and editors, but also tech people who see the noble mission of providing quality, independent journalism? In particular, can a bigger voice or a greater role be accorded to the internal staff, some of whom I know have been pushing for change for a long time and love their jobs as SPH journalists, in spite of the business uncertainty and in spite of all the accusations that they have partisan motives? They could have really good ideas under bold and inspiring leadership. My second clarification, and this is regarding to vernacular newspapers. I would like to know if the preservation of Berita Harian and other vernacular newspapers will be an explicit condition for government funding, or if funding is given by other sources, will there be a mechanism to ensure that these vernacular newspapers, so important to our nation building, are explicitly retained? Finally, I just want to say that journalism has always and will continue to benefit from various forms of subsidy, support, and benevolence from various actors. Why? Because as Joseph Pulitzer once said, our republic and its press will rise and fall together. So we do need solutions that enable high-quality, independent journalism, not least local news and vernacular news, informing the communities about the events and people affecting their lives. Thank you.
Minister, would you like to reply to those clarifications?
Thank you, Deputy Speaker. I thank the member for first the note of optimism that she has struck, because in discussing this, the merits, the challenges, the concerns, and so on, I think we must not lose sight of the fact that this is an opportunity for the organization and the people within to embark on their journey that they have traveled on up to now, but with a new beginning. And I think that is the key thing. And in considering that, I do want to make the point, because the member said, will this CLG behave like a startup, or will there be just incremental change? And I think the best way I would put it is this. You want the zest, the energy, the drive, the invention of a startup, but you do not want to lose the credibility, the trust, the quality, the people that you have nurtured all through these years. So we want to have our cake and eat it. We want to be able to do both. And I think it's very important that we recognize that, because it's not about jettisoning everything and starting from scratch, but neither is it about being so hidebound that we are not prepared to discard some of the older or long-held propositions from a business point of view in order to pursue new ideas. So I think we need a bit of both, or rather we need a lot of both. And this is where I think, as the member has mentioned, the staff, the people who are within, are just as important as the people who are without, who will be brought in due course to complement the capability of the organization. Because I think the people who have been with the organization, the journalists, the editors, the other staff, they bring a very valuable perspective. And I think that has to be a part of the equation going forward, just as we need to bring in, whether it's technology-oriented people, but others who will be able to contribute and complement. And therefore, I think the most important thing here is having a team that brings together the best capabilities in order to maximize the chance of success for this new CLG venture. And I think this is something Mr. Corbin and I'm sure the team would be very seized with, including a process of finding not just an appropriate CEO, but filling other talent requirements within the organization. The member raised another very important point which pertains to the vernacular media. As I said, the stresses that the industry is under today, and in particular SPH media, means that if nothing were done, then the capacity within the newsrooms would diminish because cost-cutting would be inevitable. And I think amongst the first and most at risk will be the vernacular media, because they have got a smaller circulation. And if you take a purely business logic to this, then I think the outcomes can be quite detrimental from a national cohesion point of view. And so, certainly, as I have said, we want to preserve the voice of our vernacular media. This is an important part of what my colleague Mr. Edwin Tong has called the tapestry of Singapore society. And we have to make sure that we pull that and ensure that that remains an important part of the overall entity that is the CLG and all its news media operations. So I think we would want to be very clear about this aspect, but how they achieve it is, I think, a different matter. So if I can put it another way, the members' questions were around what are they going to do, how are they going to do it, whom are they going to do it for, and what price are they going to impose, and the financial model. All of these are very important questions, but they're not questions that the government should be answering. because ultimately we have to put it to the board, management, and for them to come back and tell us exactly what they have in mind, what are the pivots and changes, maybe even reinvention they envisage, and in that context, then what we need to do or what we can do from the government to support them.
I see many hands. It looks like many members want to be part of this narrative, this important narrative. I'd ask for the members to keep their clarification short so that I can call on both sides of the House and give each member who wants to speak a chance to speak. So clarifications very short, please. Mr. Leon Pereira.
Thank you, Mr. Deputy Speaker. So very briefly, as we've been enjoined to do, I think with this latest move, the government seems to acknowledge that commercially it is very challenging to run media operations, hence the transition to the CLG structure. Given this context and given the Nppa regime where broadsheet newspapers need to obtain Nppa licenses, going forward, will the government consider practicing a light touch in awarding licenses to Singaporean-owned companies who feel that they might want to enter the space and give it a go because they feel that they can innovate and somehow overcome, these commercial hurdles, as some media organizations in other parts of the world, like The Guardian in the UK, for example, have done. Secondly, I welcome the Minister's emphasis that the new entity must be seen to be non-partisan, objective, and independent, and to that end, would the Minister consider either the CLG doing this or the government doing this to set up KPIs that are regularly measured to ensure that the public actually believes in the independence of the new CLG in its editorial independence, and to measure that regularly, given that taxpayer monies will be pumped in. And lastly, I'd just like to ask a question about how senior editorial appointments in the new CLG will be made. So in his memoirs, the former chief of SPH, Mr. Chong Yip Sing, wrote on page 432, and I quote, "The Newspaper and Printing Presses Act gives the government veto powers over who gets to edit newspapers," unquote. Now, he's referring to his experience some time ago. I asked a PQ more recently about whether the government plays a role in newspaper editorial.
Mr. Pereira, could you just ask your clarification?
Yeah. So it appears that the government doesn't. So my question would be, would the Minister consider creating a structure within the CLG to ensure that senior editorial appointments are seen to be independent and safeguarded from any kind of influence whatsoever, and that is seen to be the case? Thank you.
Your indulgence, just I thank the member for his questions. The first is Nppa and whether we would have a light touch and allow more entries into the market. First of all, I think when we are addressing this, let's diagnose the situation correctly. As I said, the issue is not around Nppa or no Nppa restrictions. It's not around government funding or not government funding. It's actually a circumstance that is the result of technological trends which have now made the financial model of the news media a much more challenging one. So we need to address that squarely first. But can we allow more entries into the market? I think we have a fairly vibrant news media. I'm not sure that they're all going to be in the traditional mode. You would know that, for example, we have some newer players like the motherships, like Rice Media and so on. And I think what we are essentially saying is, on the one, you have to look at it as an overall ecosystem. And it is an ecosystem where we will have new entrants coming in. You will also have some of our traditional mainstream media, in this case MediaCorp, as well as SPH News. And we also have the international media who have a very strong presence here in Singapore. So we have to look at it on an ecosystem perspective. It's not about singularly pursuing one aspect, but it's trying to ensure the overall local media grows and is able to hold its own vis-a-vis some of the broader competition it faces and the challenges we've talked about. So that's the context in which I think we will look at it. Secondly, KPIs. Will there be KPIs for... I think it's... I understand what the member is saying, and if I could refer him back to what I said in my earlier comments, not just in the Ministerial Statement, but subsequently. In fact, that has been one of the key things we look at. So as I've said, it's not just what Singaporeans say, which is important in surveys, etc. It's also what they do in terms of which sites do they go to, how many page views are you getting, what is the dwell time, and so on. And these are all metrics, and I think the member would be very aware that there are various metrics that can be used in order to measure this, the engagement of the audience. And this is certainly something that we would want to ensure is achieved. And I think if people do not trust our local media as a credible source of information, then I think these metrics will suffer. I wanted to just make one clarification. On senior editorial appointments, the government does not exercise a veto on those appointments. The decisions on those are made by management. Shareholders have a say in that matter. So I think just to be very clear, the government, has a say on some other matters, but when it comes to the senior editorial appointments, it's all subject to the management shareholders' approval.
It's Nadia Samdin.
Thank you, Mr. Deputy Speaker, sir. I've got two clarifications, please. First, we know that journalists play a critical role in society and nation building. I would like to ask, what impact will the restructured model have on the lives and livelihoods of existing SPH media employees? In addition, is there likely to be any further downsizing as part of the transfer of SPH's media business to the CLG? And if so, will the government ensure that any employees in transition are supported? My second clarification in Malay, please, sir, adding on to my honourable colleague, Ms. Mariam Jaffar.
Vernacular papers such as Berita Harian are important to our community and a source of information, especially for our senior citizens, which highlight stories of pride, interest and concern to the society. I'd like to ask whether the government funding will include support for the mother tongue newsrooms to continue the digital transformation and ensure there continues to be choice and diversity in our media landscape.
So, Deputy Speaker, I thank the member. I share her, and I think we all do, the desire to ensure that our journalists continue to be able to pursue rewarding, fulfilling careers in this very important profession. And indeed, we want to ensure that that continues to be the case even after this restructuring. Specifically, are there any retrenchments, rationalization? The terms of the proposal, as I understand it as of now, is to have the entire team move over, and therefore no attritions are intended. And I also believe that The desire is more to build on the capabilities that we have and to see how we can attract new talent to augment what is already in there. So I think the first order of business for the chairman and the CLG board and management would really be to, amongst other things, as I said in response earlier to Ms. Jessica Tan, is really that it's not just about the business aspects and the financial aspects, but it's also about the people aspects. And this must be given importance. And this is something that we, from the government perspective, we think it's critical. Because, to reiterate a point I made earlier, it doesn't make sense to talk about quality journalism if you do not have the quality journalists and editors in the newsrooms, and that's key. On the vernacular media, and I think the member's point was specifically about the Malay media, I again want to reiterate the response that I gave to earlier to Ms. Mariam Jaffar. Essentially, the vernacular media is a key part of our news media in Singapore because of the voice it gives to the different communities, no matter their size, and through that, giving them a say and a visible participation in the common space. So I think it is something that is treasured, something that we have nurtured through the years, and it is not something that we want to lose. So certainly, in the course of this transition, we would want to ensure that that commitment to our vernacular media remains. Now, how the vernacular media itself evolves, what path it takes, that I think is something we should have a more open mind about, because in the end, it has to adapt to the needs of the community, the needs of its readers, and work out a model that sustains the interests and earns the trust of the community it serves.
I'll allow two more clarifications, Mr. Pritam Singh, and then closing with Ms. Tim Pei-Ling.
Thank you, Mr. Deputy Speaker. Just following up from my first list of clarifications. Yes, I asked about the time when the government first informed SPH that it was prepared to extend grants to support its media business, and I also asked about the size of that grant. I would be surprised if the government hadn't considered what would be the extent of the grant that it would extend to the CLG. So can the Minister share with us if there's any ballpark figure as to what is the amount of taxpayer dollar that will be going to the CLG? Minister made a point about the standards of journalism. It's not a simple issue to address in the course of a ministerial statement, but my generation at least remember this headline, this cover page in the new paper, which was in 1997, at a very sensitive time just during the elections, and it was a checklist to help you decide how to vote. Minister spoke earlier about objectivity and balance. The only thing objective about this cover page is the EPL scores, no win for Liverpool and also for Manchester United. The checklist essentially told the voters what you're voting for. If you vote for the PAP, you're voting for upgrading EduSafe and MPs of acceptable character.
Mr. Singh, if I could ask you to seek your
Deputy
clarification
Speaker,
rather than
I will
expound in a speech. Thank you.
I will come to that, Deputy Speaker. Thank you, and I'll be brief. But I would agree with the Minister to the extent that one has to be fair to the journalists, because they are good journalists. And a good example is on the 1st of May this year, the Chinese media group head of Chaopao, Li Huiling, she asked some very serious questions about the leadership transition between to the 4G leadership. And she said internal competition is intense. There's no consensus to pick anyone. And on the other hand, the English papers, major cabinet reshuffle, but now is not the time to read the tea leaves. So there can be different views on the quality and the standards of journalism. And it is for that reason that I put my earlier question to the Minister about a select committee and to try and get some understanding from the public what they expect of a taxpayer-funded CLG. I note the comment Minister made about the surveys, but I think this is an opportunity to hear from the public, and I hope the government can consider this favorably.
Mr. Deputy Speaker, I'm disappointed that the Leader of the Opposition has decided to make political capital out of something that I think is quite fundamentally important to us. And I think even in the examples that he cites, in a way, he has already illustrated the point that I'm making. He went back to 1997 to bring out an example, and then he says, just last year, the Chinese media put forward this year, Chinese media put one point of view, and the English media put another point of view. Isn't this the diversity that we want? Isn't it the diversity that the Leader of the Opposition has been talking about? So I am not very clear why he thinks the current model is not succeeding. Is it perfect? No. I would challenge him to show me a model that works and that is perfect. But is it one that works in our context? I think it does, with some areas for improvement, certainly, but it's an evolutionary process. And even in the examples that the leader cites, I think it's quite clear. And I would add that what we want, what we want at the end of the day is not posturing, but substance. So if we can achieve that, not just in the news media, but also in this chamber, I think we would have gone a long way to building a stronger country and nation. As for the funding, he asked for ballpark numbers, but that's precisely the problem, isn't it? I think we should be talking about these sorts of matters when we have greater clarity. Because to throw a ballpark number, and if I give you a range, then the question will be, oh, it's a very big range, can you narrow it down? And if I say, no, I can't, then we go back to square one. So the point is, I think we are doing the responsible thing here from the government's point of view. Not just to say that we support the restructuring, because we could have stopped there, but we went a step further to say that we would be prepared to fund that CLG. That is a significant point which should not be overlooked. And clearly, when the funding is finally decided upon, it will have to come back to this chamber, because it will be part of the budget of the Ministry of Communication and Information, and the member and his party would have ample opportunity to ask all the specific questions. But I think let's not miss the wood for the trees. I think it's not about the details right now, it's about the overall thrust of what we are trying to do. Is it the right thing to do? Is our news media an important public good that we should be supporting? And if so, has it done a good job up to now in the models that we have used? And if yes, then let's work with that and build on it, rather than talk about a complete wholesale overhaul.
Mr. Nppa.
Thank you, Mr. Deputy Speaker. Two clarifications. The first one in Mandarin, please. 双语政策是我们本地的教育体系非常重要的一个特征。
Bilingualism is an important characteristic of our education system. Being able to be bilingual helps us to stay connected with our mother tongue cultures, and it is strategically important to Singapore's ability as a cultural and economic bridge. So I think this is important. If we are able to ensure the high standards of the vernacular newspapers, then it is very important. And the Minister has said that they will ask to preserve these vernacular newspapers. So what I want to ask is, since the government will provide funding for this CLG, then can we also expect them to maintain the high standards of their content, including the reporting of international news and also in terms of analysis? So I would like to ask the Minister, our Lianhe Zaobao has won a hard-earned award, international award. So I hope that the Minister can give us more information on this.
Internationally. I think this is very important. So helping our papers to be able to be circulated internationally, I think, is a very critical part, in addition to the national cohesion, national public good in Singapore. So again, I would like to ask Minister whether this is something that is on the agenda or one of the parameters that we may require the new CLG to look into in the move ahead, and whether there will be resources or funding set aside to build such capabilities. Because establishing Singapore's thought leadership and mindshare internationally is important. So how can we build up that ability to ensure that we can be circulated internationally? Thank you.
Mr. Deputy Speaker, I thank the member for her points. I think it's very important that we take this opportunity to once again reiterate the commitment to the vernacular media as part of this and any future restructuring or other changes that may occur. They are important pillars in our multi-ethnic fabric. And I think I have made the point about the important role that they play, and in particular about giving voice to the particular community. And for that reason alone, we should be focused on how we can give them not just resources, but really the motivation and ambition to be more. And I think that is the other point that the member has raised, which is from an international point of view. And for example, and I think specifically in the context of, say, the Chinese media, I am sure it will not be lost on many within the SPH organization, but also those who are going to be involved later, that our Chinese media has significant potential to not just cater to the needs of Singaporeans, but also to be able to present a perspective on international affairs. And I think it will be a very valued one because it will represent the Singapore point of view, which would be seen as being objective. And it will also be one that would be valuable to Singaporeans because it will be a chance to understand some of these international developments through the lens of Singaporeans and how they assess this in terms of its impact on us and our long-term interests. So for all those reasons, I think we will want to make sure that the vernacular media doesn't just pivot to digital, but actually develops additional important capabilities to meet this, broader need that we have. And I think this is something that I will have to defer to the CLG chairman and the members of the board and management who will then have to take this forward. But I think from a government point of view, certainly there should be no doubt as to where we stand on the issue. And I thank the member for bringing it up.
Order. End of Ministerial Statement. Introduction of Government Bills. Second Minister for Home Affairs.
Then I agree with you. No, you can use the other one.
Mr. Deputy Speaker, on behalf of the Second Minister for Home Affairs, I beg to introduce a bill entitled An Act to Provide for Registration of Births, Deaths and Stillbirths, to repeal the Registration of Births and Deaths Act, Chapter 267 of the 1985 Revised Edition, and to make consequential amendments to certain other acts.
The Registration of Births and Deaths Bill.
Second reading, what day?
At the next available sitting, sir.
So be it. The Minister for Social and Family Development.
Mr. Deputy Speaker, on behalf of the Minister for Social and Family Development, I beg to introduce a bill entitled An Act to Amend the Mental Capacity Act and to make a related amendment to the Electronics Transactions Act.
Mental Capacity Amendment Bill.
Second reading, what day?
At the next available sitting, sir.
So be it. The Minister for National Development.
Sir, I have a certificate of urgency signed by the President in respect of the COVID-19 Temporary Measures Amendment Number 3 Bill to be laid upon the table.
The certificate is in order. Minister, please proceed.
Mr. Deputy Speaker, I beg to introduce a bill entitled An Act to Amend the COVID-19 Temporary Measures Act 2020.
The COVID-19 Temporary Measures Amendment Number 3 Bill.
Minister, second reading when?
Mr. Speaker, sir, copies of the bill have been provided to the clerk, who will distribute it to members now. And with regards to second reading, tomorrow, sir.
So be it. Order. The clerk will now proceed to read the orders of the day.
Item 1, the Significant Infrastructure Government Loan Bill, second reading.
Deputy Prime Minister and Minister for Finance.
Deputy Speaker, sir, I beg to move that the bill be now read a second time. So first, let me set the context behind this bill. To do so, may I ask the clerk to distribute the handout, please?
Please do.
And members may also access this handout through the SG Parliament MP mobile app. Now, Mr. Speaker, over the next 15 years, Singapore will be making bold investments in major infrastructure that will benefit both the current and future generations. This generational upgrade in our infrastructure will greatly enhance the connectivity
livability, and sustainability of our home. Taken together, we expect an upcoming harm in development expenditure of around 5% of GDP annually, higher than our baseline or average development expenditure of 3.7%. This expenditure is over and above infrastructure investments that we will continue to make in areas like building more healthcare and education facilities. We plan to build new MRT lines, such as the Cross Island Line and Jurong Region Line. MRT is the most efficient and greenest mode of transport. We want to raise the mass public transport modal share during peak hours from 64% now to 75% by 2030. New MRT lines will also move us closer to the vision of a 45-minute city with 20-minute towns by 2040 and bring greener transport options closer to more Singaporeans. Another example is the Deep Tunnel Sewage System, or DTSS. The DTSS will meet our long-term needs for used water collection, treatment, reclamation, and disposal. As part of the second phase of DTSS, the Tuas water reclamation plants will be able to treat up to 800,000 cubic meters of used water per day. This is equivalent to 320 Olympic-sized swimming pools. This will enhance our water resilience in the face of larger fluctuations in rainfall. Other examples of major long-term infrastructure that we are building or expecting to build include major highways, such as the North-South Corridor, which will alleviate congestions on the CTE, as well as coastal protection infrastructure to protect us against rising sea levels caused by climate change. Agencies are already embarking on site-specific studies at our coastlines to examine potential measures like seawalls and polders. We expect more expenditure on climate change beyond 2030. This bill before the House today will permit the government to borrow for these major long-term infrastructures, subject to strict safeguards under the new Significant Infrastructure Government Loan Act, or SINGA for short. Given this upcoming harm in development expenditure that I just described, borrowing is a fair approach because it allows each generation that benefits from the infrastructure to pay for its share. Otherwise, taxpayers in the next decade will need to finance much of this lumpy infrastructure that has a useful life of 50 years or more. Borrowing in this context is also efficient. First, with Singapore's AAA rating, we are likely able to tap the debt market at favorable interest rates. Second, by borrowing instead of drawing on investments, our reserves can remain invested to earn returns. We can tap on these returns to supplement our budget through the Net Investment Returns Contribution, or NIRC. Other alternatives to borrowing include raising taxes temporarily, diverting resources from other spending needs, such as social spending, or delaying significant infrastructure investments. However, all these options will be less efficient and more costly to the nation. Borrowing for infrastructure is not new. As a fledgling state with no natural resources, we have borrowed to finance large infrastructure investments to help build Singapore in the past. Singapore launched our first development plan in 1961, an ambitious $871 million plan to kickstart industrialization and economic development. We borrowed from the World Bank and Asian Development Bank and paid these debts back steadily and on time. In the 1980s, we borrowed to finance a wave of major infrastructure projects that we continue to benefit from today. These projects include Changi Airport Terminals 1 and 2, and our first MRT lines, the North-South and East-West lines. By the early 1990s, our economy was growing rapidly, aided by our young demographic. This led to buoyant revenues, which allowed the government to meet all its expenditure needs and pay down the earlier debts. In addition, with prudent management of our finances, we're able to run healthy budget surpluses and build up our reserves. There was no need for us to borrow to pay for major infrastructure expenditure. While we must continue to build for our future, including significant infrastructure such as MRT lines and coastal protection infrastructure, our economy and demographic are now more mature. Given our aging demographic and less scope for catch-up productivity growth, we cannot expect our economy to grow rapidly in the future. Hence, we will not have the same buoyant revenues as before to pay for large infrastructure expenditure upfront. Instead, we will reactivate government borrowing. Our approach on borrowing should remain prudent and disciplined. First, we will not borrow for just any kind of development expenditure. We'll set a high bar for qualifying projects that can be financed by borrowing. Second, we must ensure that we do not overly burden future governments with high debt servicing costs, which will reduce the resources available for spending or worthwhile services and subsidies for our people. Hence, we will impose both strict borrowing limits and interest limits. We have benefited from the prudence of previous generations who set aside surpluses then when our economy was growing rapidly. This is why we have our reserves and a reserves protection framework. Let us not forget that the opposite of reserves is debt. Today, the NIRC adds about 3% of our GDP to our total revenue. For most advanced economies, 1 to 3% of GDP is spent on debt servicing costs. We must be careful not to slide from a position of having net assets to one of having net debt. Otherwise, instead of having assets that earn a stream of earnings to add to our revenue for future spending, we will be committing resources to servicing debts incurred by earlier generations. Mr. Speaker, I will now explain how we have included these safeguards in the bill, which will apply in addition to the Reserves Protection Framework. The earlier Development Loan Acts in the 1960s to the 1980s that permitted government borrowing for spending on development did not set out criteria for the types of development that qualifies. However, given that our economy is maturing and we are no longer expecting the same high growth and high fiscal surpluses as before, we have set out a prudent and disciplined approach. Today, all government development projects go through a rigorous multi-stage evaluation process to ensure project worthiness and cost effectiveness. All infrastructure projects will also need to obtain ministers' approval before they can be built. Single projects will undergo the same scrutiny. In addition, under the single bill, nationally significant infrastructure projects must satisfy 4 requirements. 1, it must be major in size. 2, it must be important to Singapore's national interest and benefit the general public. 3, it must last multiple generations. And 4, it must be owned by the government. First, nationally significant projects will have to cost at least $4 billion. This is set out in Clause 11.5a. Nationally significant infrastructure projects tend to be big-ticket items as they are major and complex in nature. The $4 billion threshold will capture major lumpy development needs that form the upcoming hump above our baseline development expenditure. You also exclude smaller scale infrastructure such as schools and polyclinics. Such smaller scale infrastructure make up the base of our annual development expenditure and should continue to be funded from taxes and other revenues. Clause 11 of the bill sets out the criteria for determining the cost of the project. First, Recurrent expenditure related to the nationally significant infrastructure, such as cost of repair and maintenance and purchase of vehicles, is excluded. Second, the cost of acquiring land is excluded as well. Third, the bill permits projects to be built in phases, such as our MRT lines. Where these phases have been planned for right from the start, the cost of all phases of the infrastructure projects can count towards a $4 billion threshold if the different phases or components of the projects are linked either fiscally or operationally. In short, we can view such a project as one system of integrated and interconnected components. For example, the cost of the entire cross-island line will count towards the same project value threshold because all its station and rail tracks are fiscally connected to each other. The entire cross-island line is also expected to operate in its entirety, interchanging with other MRT lines existing and planned. Now, in the case of different infrastructure components that are required to protect us against rising sea levels, they are linked operationally but not fiscally. They may not be physically connected to each other because they may be triggered at certain locations. However, the cost of these components will also count towards the same project value threshold because the components need to work in tandem to protect our coastlines. For separate infrastructure projects that are not linked fiscally and can operate independently, the SINGA does not permit these projects to be bundled together in order to meet the $4 billion threshold. For example, the cost of individual hospitals will not count towards the same project value threshold as each hospital can function as a standalone. When one hospital is down, other hospitals can continue to run, and they may even pick up some of the slack in providing healthcare capacity. In contrast, if a component of an MRT line or coastal protection infrastructure is not built, the whole system would not be able to function as intended. I turn to the second requirement, which requires the infrastructure project to be important to our national interest and benefit the general public in Singapore. This is set out in Clause 2 under the definition of nationally significant infrastructure as being one that is likely to materially improve national productivity or Singapore's economic, social, or environmental sustainability. And in Clause 2 as being intended principally for use by or for the benefit of the present and future generations of the general public. New MRT lines will qualify because this enhances livability, promotes economic activity by improving connectivity, and are the greenest mode of transport in the long run. The bill provides a list of examples that meet these objectives, such as transport infrastructure, climate change-related infrastructure, as well as utility network infrastructure. This list is non-exhaustive. This is because we can never know today what we may need in the future. What is important is that we are targeting those projects with benefits that accrue widely to Singapore as a whole or to a large majority of our people. In order to adhere to the spirit of this thinking, without trying to predict too far into the future, we have safeguards that I've mentioned earlier to ensure that the government will use this carefully. The third requirement, as set out in Clause 11.2, is for the resulting nationally significant infrastructure to have a useful life of at least 50 years. This ensures that the infrastructure projects will benefit more than one generation of citizens. To be clear, the useful life of an infrastructure is not necessarily the same as its fiscal life. The fiscal life can be shorter if we expect that the infrastructure may no longer serve its intended function sometime in the future. For example, it is likely to be rendered obsolete by technological advances after a period of time. We will use the useful life of the infrastructure to determine the depreciation period of the capitalized assets. This is fair as it ensures that depreciation costs are spread only across generations who will benefit from the infrastructure. Lastly, all nationally significant infrastructure financed by borrowings must be legally owned by the government. This ensures that the qualifying infrastructure assets can be capitalized on the government's accounts. In addition, the assets must be controlled either by the government or another entity on behalf of the government. This ensures that the government remains ultimate oversight over the infrastructure assets to incentivize proper upkeep and maintenance so generations of Singaporeans can benefit. To give an example, the North-South Corridor will qualify under the SINGA because it is an asset owned by the government and is controlled by another entity, namely the Land Transport Authority on behalf of the government. The 4 qualifying requirements that I've touched on set out the projects that can qualify as nationally significant infrastructure. In addition, the bill sets out limits to ensure that the amount the government borrow is equitable and sustainable. This is to ensure that future generations are not saddled with a high debt burden. Clause 5 imposes 2 restrictions: a gross borrowing limit and an annual effective interest cost threshold. Together, these restrictions ensure that future governments will be able to afford the principal and interest costs while having sufficient fiscal space to fund their priorities of the day. The gross borrowing limit is set at $90 billion under the bill. This sum reflects a projected pipeline of nationally significant infrastructure over the next 15 years after adjusting for inflation. $19 billion is approximately 20% of today's annual GDP at current market prices. This is lower than the borrowing limits of Development Loan Acts, which previously allowed the government to borrow for development expenditure in the 1960s to the 1980s. Previous borrowing limits averaged 40% of GDP in the year the acts were introduced. It is thus a reasonable figure given our more mature economy. I should emphasize that the borrowing limit is a gross limit and not a rolling limit. Once the government has raised a borrowing under SINGA, that amount will be counted towards the total borrowing limit, even after the loan has been repaid. After the $19 billion limit is reached, the government will have to amend the borrowing limits by passing a new bill in Parliament in order to borrow further sums under SINGA. In doing so, it will need to justify such further borrowings to finance infrastructure projects that are of national importance. In other words, this bill that we are legislating is limited to enable the government of the day to borrow to meet the significant infrastructure needs in the coming years up to a maximum of $90 billion as we undertake this generational upgrade. If there are further needs beyond the $90 billion, future terms of Parliament will have to debate and approve further measures to meet these needs. As set out in Clause 5.2, the refinanced borrowings will not count towards this $90 billion limit. This is because there's no corresponding spending on and capitalization of significant infrastructure. Allowing for refinancing gives the government of the day the flexibility to manage borrowing costs efficiently across interest rates cycle. For instance, the government may issue bonds across a range of tenors and refinance when the bonds mature. Hence, the bill provides for borrowings for the purpose of refinancing even after the $90 billion borrowing limit is reached. The second restriction is an effective interest rate cost threshold of $5 billion per annum. $5 billion interest against the $90 billion cap works out to be an effective interest rate of about 5.5%. This threshold ensures we limit our borrowings when interest rates are very high, as interest costs will have to be borne by future generations. This annual effective interest cost will be calculated based on the effective interest cost paid in the preceding financial year. If the effective interest rate paid exceeds $5 billion, the government will not be allowed to borrow more in the next financial year. Allow me to illustrate how the threshold will work. The recent 30-year SGS that was auctioned in January 2021 had a cut-off yield of 1.4%. If we borrow the full $90 billion based on this rate, the annual interest cost will be $1.3 billion, which is below the $5 billion threshold. But we cannot expect interest rates to remain at low levels forever. Historically, the longest period where SGS yields remained low did not last for more than 2 years, and this was in the aftermath of the global financial crisis from 2011 to 2012. So interest rates may continue to stay low or may increase in the future, and we have to be prepared for that. In fact, the cut-off yield of a 30-year SGS went up to 2.94% in February 2018, which is not too long ago. We have also examined the interest rate trends for SGS over the past 25 years. Cut-off yields of SGS with tenors of more than 10 years have ranged from a low of 0.93% as recently as July 2020 and to a high of 5.87% in 1998 when global interest rates were higher. The $5 billion threshold thus provides some buffer for us to cater to such scenarios. We will, however, limit the maximum amount that can be borrowed if interest rates are overly high, and the interest cost threshold achieves this objective. For example, if interest rates average around 10%, then the interest cost threshold will constrain the amount of borrowings under the SINGA to $50 billion, notwithstanding the gross borrowing limits of $90 billion. Setting the threshold at $5 billion, therefore, helps us to balance between fiscal sustainability and flexibility to accommodate market fluctuations. A $5 billion threshold caps the interest cost at around 1% of our GDP in 2020 at current market prices. This is a fiscally sustainable level and would not excessively impinge on future government's ability to fund other priorities of the day. It also provides a buffer to account for interest rates rising and falling through the cycle as the government borrows at different points in time to finance the infrastructure as and when we need to build them. Let me elaborate. The cost of borrowing is fixed at the prevailing yield during each bond issuance. As the government issues bonds over several years, it will lock in interest rates at different points in the interest rate cycle. This means that even if some borrowings needed to be made during periods of high interest rates, there would have been borrowings that were made or will be made during periods of low interest rates, so the cost of borrowing will be averaged out over time. Further, the $5 billion threshold translates to borrowing costs of 5.5% for a $90 billion borrowing, which is high relative to historical borrowing rates. The last time when 10-year borrowing costs exceeded this level was in 1998. With all its fiscal expenditure, the government will be transparent in reporting the use of borrowings to finance nationally significant infrastructure. When borrowings are used to meet progress payments for nationally significant infrastructure, such spending will be reported in the annual budget, statement, and the government financial statements, together with annual depreciation expenses and interest costs. Additionally, we will submit a statement of assets financed under SINGA to the President annually to ensure accountability. So let me now explain how the bill will impact our current reserves and annual budget balance. Presently, the development costs of infrastructure are financed using revenues accruing to the current reserves and fully expensed upfront in the annual budget. In other words, the government's annual budget balance is reduced by the full development costs of any infrastructure that is paid in that year. With borrowing, the government will be able to raise cash to meet the outlays for these major long-term infrastructure projects. But borrowing is not revenue and does not increase the current reserves that we can allocate in the annual budget. This is why the bill also provides for the capitalization of infrastructure projects that are financed under SINGA. In other words, the development costs of major long-term infrastructure will be financed using borrowings raised under the SINGA, capitalized as assets, and depreciated over the useful life of the infrastructure. Depreciation of SINGA assets, as well as borrowing costs, will be expensed against the annual budget balance and will reduce the current reserves of each term of government over the asset's useful life. As such, development expenditure financed by SINGA will affect the current reserves differently compared to regular development expenditure. The budget presentation will reflect this treatment. This better matches the timing of benefits with the timing of spending. Present and future generations of Singaporeans will both contribute to and benefit from such infrastructure. Put together, this approach will smoothen the upcoming hum in development expenditure and lower our average development expenditure over the next decade from around 5% of GDP to 4.2% of GDP after taking into account depreciation and borrowing costs. Let me explain using an example. Assuming an MRT line costs $14 billion and has a useful life of 70 years. Currently, we will expense a full $14 billion upfront, which reduces our annual budget balance by the full $14 billion over the construction period, which may be over a period of, say, 10 years. And assuming equal progress in every year, this would mean expenditure of $1.4 billion per year. Under SINGA, the $1.4 billion cash payments for each year will still form part of the development estimates in our annual budget, which are subject to Parliament's approval and President's assent. However, we will add back this $1.4 billion in computing our annual budget balance, as this $1.4 billion will be capitalized as an asset. Upon completion of the construction, we will spread the total development cost of $14 billion over the MRT line's useful life of 70 years by expensing annual depreciation costs of about $200 million instead. This means that our annual budget balance will be reduced by $200 million over 70 years before borrowing costs. Clause 29 of the bill will amend the Financial Procedure Act to allow for nationally significant infrastructure financed by borrowings to be capitalized by assets and depreciated over the useful life of the infrastructure. The resource protection framework will continue to apply as well. If the government runs a deficit, including depreciation and borrowing costs of single assets, and do not have sufficient current reserves, there will be a draw on past reserves. Each term of government will need to run a balanced budget over its term, maintaining the fiscal discipline to ensure that we do not spend beyond our means. This fundamental principle remains unchanged with SINGA. We have sought President's in-principle support in February this year for government to borrow for and capitalize nationally significant infrastructure under SINGA. And as with the case for all bills to become law, we will also seek President's assent to this bill. Under Article 144 of our Constitution, President has the discretion to withhold assent to any bill providing for the borrowing of money by the government if she is of the opinion that the bill is likely to draw on past reserves. Only after Parliament has passed and the President assented to the bill will the government be able to borrow for nationally significant infrastructure up to a gross limit of $90 billion. Mr. Deputy Speaker, sir, I would like to make it clear that this bill introduces a new form of government borrowing to finance spending on nationally significant infrastructure. This is distinct from existing borrowings under the Local Treasury Bills Act, or LTBA, and Government Securities Act, or GSA, which are for specific non-spending purposes, such as for market development, meeting the investment needs of CPF, and liquidity. All borrowing under the LTBA and GSA are invested and cannot be spent. Even if we were to borrow up to the $90 billion limit under SINGA to finance nationally significant infrastructure, the majority of our borrowings will continue to be under the LTBA and GSA, which are for non-spending purposes. Some commentators have incorrectly interpreted our high gross debt to GDP ratio as a sign of fiscal imprudence, when in fact our assets are well in excess of our liabilities. To address these misperceptions, we intend to clearly delineate the two types of borrowing in legislation. First, borrowings to finance spending on nationally significant infrastructure under the SINGA, and two, borrowings which are invested and cannot be spent under the LTBA and GSA. We intend to merge the LTBA and GSA into a single act, as both are for non-spending purposes. The merger bill will be tabled in Parliament in the coming months. In addition, the bill repeals the Development Loan Acts, which previously allowed the government to borrow for development expenditure in the 1960s to 1980s. This makes it clear that borrowing for developmental purposes going forward can only take place under the new safeguards that are imposed under the SINGA. Mr. Speaker, sir, let me now conclude. In 1965, shortly after Singapore became an independent nation, Mr. Lee Kuan Yew said, and I quote, "Over 100 years ago, this was a mud-flat swamp. Today, this is a modern city. 10 years from now, this will be a metropolis. Never fear," unquote. Since independence, infrastructure has played a major role in Singapore's remarkable fiscal transformation from mudflat to metropolis. We built a world-class airport that has made us the open, globally connected city we are today. We created our first reservoir in the city and the largest reservoir in Singapore, the Marina Reservoir, by building a dam to keep out seawater. This innovative method provides us with an additional source of water supply and helps alleviate flooding in low-lying areas of the city. Downtown Line, which opened in end 2015, reaches out to residential areas such as Bukit Panjang, MacPherson, and Bedok Reservoir. They were previously not served by the MRT, cutting travelling time for Singaporeans living in these areas and connecting people to the city centre. Moving forward, infrastructure will remain important as our country enters into its next phase of development. We'll turn our metropolis into a green global city that is robust in addressing future challenges. We're building a sewage system that helps us recycle every drop of water in a never-ending loop. We'll bring green and efficient transport options closer to more Singaporeans. We'll build coastal protection infrastructure to protect our coast from rising sea levels caused by climate change. And in so doing, we'll build a Singapore where we and our children can live our best lives in a safe, green, and livable environment for all time and seasons to come. This bill will allow the government to borrow so that we can make bold and necessary infrastructure investments that are critical to Singapore's long-term development, just as our forefathers did. It provides an additional fiscal tool to continue to build Singapore for the future. It adheres to a prudent fiscal approach by ensuring that we do not risk borrowing beyond our means. After all debt has to be paid for. If we do not borrow responsibly and sustainably, will risk being unable to meet our debt obligations. This would jeopardize our credit rating as well as investor confidence. And this will hurt us and our children in the future. This bill ensures that we borrow to spend only on nationally significant infrastructure investments, which will benefit many generations of Singaporeans to come, in line with our values of taking a long-term view and staying prudent and responsible. We are not borrowing to spend on expenditures that will be consumed quickly. Current generations should continue to pay for their own recurrent needs, like healthcare expenditure, through recurrent revenues such as taxes. This is the right and responsible thing to do. Let us share the effort to build our nation together. Most importantly, let us never stop thinking about our future. In the long journey of nation building, each generation of Singaporeans are relay runners. Let us always take good care of what we have inherited, run our best race, and pass on a better Singapore to those who come after us. This significant infrastructure government loan bill is but one step in this long journey. It seeks to do right by Singaporeans, both present and future, through the financial plans and provisions that we make today. Sir, I beg to move.
The question is that the bill be now read a second time. Mr. Liang Yinghua.
Mr. Deputy Speaker, sir, I will speak on two aspects related to this bill. Firstly, on fiscal prudence and financial discipline, whether that has been undermined with this single bill, and secondly, on intergeneration equity, a somewhat new perspective that increasingly deserves our attention. I will also briefly touch on the other tactical considerations with regards to government's long-term borrowing strategy, namely interest rate levels, credit costs, servicing and repayments of the government borrowings, as well as the development of the Singapore debt capital markets. So firstly, on fiscal prudence and financial discipline. Since independence, the overarching guiding values of our fiscal management has been to spend within our means and to maintain a balanced budget. We save whenever we could for rainy days and refrain from borrowing to pay for our expenditures. Whenever we had surpluses at the end of the term of government, we would either redistribute or endow it for specific uses, such as the Pioneer Generation Fund, the Real Infrastructure Fund, the Special Employment Credit Fund, and so on. Otherwise, we will convert the surpluses to reserves so as to grow the base, to invest, and to generate larger returns contribution in the futures. These values of prudence and discipline are also enshrined in our Constitution. The government of the day must balance the budget during the term of government. The President holds the second key in the use of reserve, and only up to 50% of the NIRC can be used to fund current and annual budget spending. There are also gross borrowing caps set by Parliament on the issuance of government debt securities whose proceeds can only be used for investments. Besides these institutional safeguards, it is also vital to have the alignment at the political stewardship level. We are fortunate to have successive finance ministers who are committed to the values of prudence and discipline. Some would say our finance minister tended to be conservative in managing the budget. Well, they should be. For a small island state like Singapore, a higher safety buffer is always wise and always serve us well too. We must always expect a major storm around the corner that could hit us, and when it does, we can take comfort that we have the resources to decisively tackle and overcome the crisis. Our prudent and disciplined management over the years has allowed Singapore to build a strong balance sheet with net zero debt and attain the highest international sovereign ratings of AAA by the global rating agencies. As a result, whenever the government taps the debt market, is able to borrow at risk-free rate or at zero credit cost. This opens another avenue of inexpensive funding for the government. So the basic question then is whether this differentiated financing strategy where we can now borrow over the long term to fund large-scale infrastructure, capital expenditure signals an increasingly less prudent management of our finances. In all fairness, the government did borrow in 1970s and in the 80s to pay for construction of the Changi Airport and our MRT lines. However, since 1990s, we have used the annual budget and the accumulated surpluses to pay for major infrastructure projects. Under this single framework, lumpy infrastructure costs greater than $4 billion can be financed using long-term debt. I've been pondering over this topic since it was first raised in 2018. Whether should we be concerned with this approach and where it could lead us to. Will this borrowing burden our future generations with high interest costs and large bullet repayments, or it is indeed timely to now be open to this long-term debt financing so that we can achieve the most optimal outcome for Singapore given the current circumstances? So let's first look at the realities before us. First reality, we do have significant infrastructure expenditures in the immediate future, and these are not small spending items. Projects like the Cross Island Line, the Jurong Rail Line, as well as the deep tunnel sewage systems are not only super big ticket outlays, but their constructions may stretch more than a decade, with benefits accruing across generations. Second reality, even if we are not in the midst of the current COVID crisis, financing such huge expenditure using current revenue or accumulated surpluses will still pose a significant strain to the annual budget allocations. Our recurrent expenditures are already growing each year, while our revenues outlook look increasingly uncertain. The massive pandemic-related relief spending have also exacerbated the strain on our books. To fund such mega long-term projects under current budget cycles, well, we may have to either cut other spending or raise taxes, neither of which are suitable under current environment. So we are indeed facing a situation of tighter fiscal headroom going forward. Should we delay these critical projects because of current budget constraint? Well, these infrastructures are necessary to enhance our capabilities and to improve our quality of life. We should get this project going soonest. Should we then just draw on our reserves to pay for these projects? If this is indeed the instinctive mindset, then we will really be going down the slippery slope. We should not see reserve as an ATM to be drawn on whenever we need money. Reserve should only be used as last resort, such as during a devastating crisis like the one we are in today. They are our last line of defense, and we really need a solid defense. Each draw on reserves also means divesting a part of our financial investments, and so we will lose out on the returns from these investments and their contribution to NIRC. Given this consideration and the current budgetary constraint, I will agree that the next best option will be to borrow for such expenditure, but with strict conditions. I note the list of qualifying criteria to borrow under SINGA, such as the minimum useful life of 50 years, and that the project should support national productivity and achieve economic, environment, and social sustainability goals. Similarly to the GSA and the LTBA, we need to also hard-code the necessary prudential safeguards so that the borrowings are indeed selective and controlled. The overall gross borrowing limits of $90 billion ensures that the government will not run into excessive debt situation and that we will have the ability to service and repay the debt. It's also important to impose an annual interest threshold to avoid overly onerous financing costs on future generations. Although, in my view, the $5 billion threshold appears to be on the high side. And the reason is because besides the interest cost, there's also the depreciation charge, which under the Singapore framework, we need to capitalize the expenditure. And these items, with both the interest cost as well as the depreciation charge, will henceforth be an additional recurring expense item in our annual budget. And this is a significantly large expense item and will make the overall balancing of the budget more challenging going forward. Hence, this option of tapping the debt market to finance very large infrastructure projects can only be palatable if interest rate remains low. Indeed, interest rates are at historical low today, presenting an opportune window for the government to seek funding. It also makes good sense to take advantage of our very solid credit ratings to enjoy zero credit cost borrowing in the market. So also from a capital market development standpoint, having such a high quality issuance will also deepen our bond market, attract a bigger pool of institutional investors to Singapore. So we are far from those countries with high public debt to GDP ratio, which transfer heavy tax burden of today onto future generations, which brings me to the next point on intergeneration equity. Perhaps the more enduring argument as to why we should introduce SINGA is that it helps better manage intergeneration equity when we fund the very large, very long-term infrastructure projects. During the early years of independence, where survivability as a nation was our foremost concern, our pioneering generations saw the need to tighten belts and save for a better tomorrow. The savings built up provided security and benefited subsequent generations, which also saw as their obligation to build on the past savings so as to provide better and more secure life for the next generations. So this is the self-sacrificing spirits of the pioneer generation as well as Merdeka generations. They supported the government's prudent fiscal policy and worked hand in hand with the government to grow the reserve and to strengthen our fiscal foundation. As we build up our nest egg over the decades, the government would regularly share and distribute the fruits of our past successes. At the same time, we also accumulate where we could so as to provide for the higher spending needs in the future. In 2009, the government tweaked the reserve framework and also introduced the NIRC as another contribution to the budget to help pay for our growing current expenditures. In a way, the 50-50 sharing of the NIR represents an intergeneration balance that we want to achieve between current and future generations. In 2015 and 2018, to thank our pioneer and Merdeka generations for their sacrifices, the government set aside a total of $15 billion from accumulated surpluses or current reserves to set up the PGP and MGP to provide for healthcare support for our seniors. The government also increased the share of budget spending in senior facilities and major healthcare infrastructures among others to care for this generation of seniors. On the other hand, in order not to pass the bucks of current spending to future generations, we strive to use current revenue to pay for this recurring expenditure, thereby ensuring sound and sustainable operating finances. The financing of our large-scale long-term infrastructures with long-term borrowing is a further manifestation of that spirit of equity. As this infrastructure benefits multi-generations, it is more equitable to share the cost across generations by way of a long-term financing structure. Though I support the government's greater emphasis on intergeneration equity in our fiscal management, we know it's always difficult to find that balance that everyone's agreed with. So while we can depend on the framework like SINGA and NIRC to seek better equity, we should never discard our long-held values and ethos of always leaving something behind for our next generation and to strengthen our future. Sir, in Mandarin, please.
Mr. Speaker, sir, the mega projects for this country and using SINGA is a very important topic. It shows us how we can treat intergenerational equity. How do we better distribute the burden and the resources between generations? In the past, our pioneers saved up what they had so that future generations can have better and more stable lives, so that we have more financial resources to be ready for the rainy day. And that was the thrift and the frugality of the pioneer generation and their values. And because of the sacrifices, Singaporeans today can enjoy the various benefits of the reserve. Because our national reserves are significant, we have the ability to withstand any unforeseen circumstances. With the maturing of the economy and the aging population, our financial policies must also be updated, especially in terms of the intergenerational distribution of financial resources and financial burden. Let me give two examples. First, of course, we want to strengthen our financial foundation. We should not change this concept. But how does each term of government deal with the question of the budgetary surplus and how to treat the investment return? We can introduce some consideration for intergenerational distribution. All these years, our reserves have become more abundant, and we can allow our present generation, including the pioneers, to enjoy the benefits and fruits of success to raise the standard of living. And that's why we introduced the pioneer generation and the Merdeka generation packages. We have improved the healthcare facilities to look after our aged. In the enjoyment of the returns, in 2009, we have changed the constitution to allow 50% of the investment return to be used in the present term government to help balance the current year budget. The other half of the return must be reinvested in our reserves so that we can continue to enjoy higher returns and meet the higher expenses of the future. I think this is acceptable and a balanced intergeneration. As a Hokkien song says, 50-50 emotions will not be, feelings will not be dissipated. So this will allow each generation of Singaporeans to enjoy the fruits of success of Singapore. Second, we have to ensure that the recurrent expenses and income will be balanced and will not have a deficit, and we can therefore sustain it for the long term. Each generation of Singaporeans, the recurrent expenses must be borne by the current generation and not through loans and other forms to spend the income of the future and passing the burden to the future. So I think this is in line with the principle of equity. So the government's proposal on the SINGA, I think, give us an opportunity to adopt within this scope a way to distribute the burden between generations. In the past, we use our present income surplus for large projects, and that's to say we're using current generation's income for the benefit of future generations. But we know that with the aging population and our expenses will continue to increase and our budget will become more and more tightened. And with the pandemic, we do not really know how long it's going to last. Our overall financial outlay and income will definitely be subject to greater pressure. If we continue to use the annual budget surplus to pay for this mega infrastructure, we will meet the need to reduce other expenses or to increase taxes. Both of these at the present stage will give us a dilemma. So with this new bill, so that we can raise long-term debt to finance mega projects to ensure that we have sufficient resources is the next best thing. So I'd like to give two reasons to support it. First, the long-term interest is at a historic low, so we can use this window of opportunity to make use of this extremely low interest rate to pay for long-term debt. Second, we can achieve our intergeneration equity by passing the benefit and the burden to future generations. For example, our cross-island rail, Jurong Rail, and the deep tunnel sewerage works. All these will bring us benefits to many future generations. Through this long-term debt, we can more appropriately spread the burden over generations so that the burden can be borne and avoid having the present budgetary fluctuations from year to year. Of course, we have the duty to ensure that we do not leave a huge debt to our future generations. So in this bill, there are certain important principles on the conditions. We can exceed 90 billion in total, and the annual repayment cannot exceed 5 billion. So these two measures will help ensure that government will not be faced with great financial problems. So I believe this bill will give us another tool to solve our financial problem, to face the uncertain future. And you give us a greater flexibility and greater space to achieve intergeneration equity.
我还有最后2个澄清之点。那么在这个今年的财
If the fiscal condition remains tight, the government consider special purpose borrowing to finance time-critical and worthy investments to avoid having to divest our financial investment in the past reserves. In his round-out speech, DPM replied that the government would study the possibility of one-off special purpose borrowing to finance economic investment to help Singapore emerge stronger from COVID-19. So can I clarify whether the government envisaged that the consideration behind such once-off borrowing would be different from those of Singa? My own thinking is that when I made the suggestion during the budget statement debate, that it should be different. Singa is meant to finance major long-term infrastructure benefiting multiple generations. I would suggest that the one-off special purpose borrowing be to finance economic investments to emerge stronger and should only be done in the context of the exceptional circumstances presented by COVID-19. For example, we may need to invest in capabilities that take advantage of the new opportunities in the global economy arising out of COVID. So if our revenues are insufficient to fund this investment due to the economic situation being subdued, then we can deploy such special purpose borrowing. And such special purpose borrowing can also be distinguished from the normal borrowing in that it is one-off, it has a clear nexus with strategies for post-COVID recovery and investments, and also help us keep our assets invested. So could DPM provide an update on this? My second clarification is, as mentioned in my speech, one of the most invaluable international accolade that we receive
Excuse me, Mr. Leung, you have to wrap up quite shortly, please.
It's our AAA rating by all 3 major global rating agencies. I believe we are among the remaining 9 countries in the world left that continue to enjoy these highest ratings. So being a AAA rated sovereign enables us to borrow at the international market at a risk-free rate. It also has implications on the borrowing cost of Singapore corporates, as bonds issued by companies are often benchmarked to the Singapore government yield curve. So can I ask the DPM if our AAA rating status could be affected with this Singa bill, and how has the rating agencies and international market responded to this new move? So I support the bill. Thank you, sir.
Ms. Fu Miha.
Mr. Deputy Speaker, the proposed Significant Infrastructure Government Loan Act, SINGA, represents a significant shift in the government's position on borrowings for the purpose of government spending. I support the bill. It is coming at a time when the country is facing another hump in its development spending needs, with plans for new rail lines, water and sewerage infrastructure, as well as coastal protection measures against rising sea levels. These important projects come amidst a tighter fiscal situation exacerbated by the COVID-19 pandemic. The proposed SINGA will enable the government to continue investing in nationally significant infrastructure, which incur heavy upfront cost but provide long-term benefits. With a low interest rate environment and Singapore AAA credit rating, the borrowing cost associated with Singa is expected to be low. Singa will make related amendments to the Financial Procedure Act to provide for capitalization of the expenditure of these nationally significant infrastructure over the long term. This is in contrast to the current approach of fully expensing off upfront in the annual budget of government. Sir, the ability to capitalize expenditure under Singa will enable lumpy upfront costs to be spread out across current and future generations who will enjoy these benefits. It will help free up cash for other needs, lessen pressure for tax increases, and trade off on competing important investments. So I have 3 questions for the Minister to clarify relating to capitalization. 1, for the Minister to provide details on how far out capitalization of projects under Singa will be allowed. 2, quantify the fiscal space created from this new accounting treatment. 3, estimate the amount of taxes that would have had to be raised to fund such long-term expenditures if these were made under the current annual expense approach. Sir, even as I support this bill, we must exercise utmost discipline in what we borrow for and the extent of our borrowing. I would like to call out the need to guard against going down the slippery slope of other countries where public debt has been accumulated to higher than that of their GDP, thereby transferring immense tax burdens from today onto future generations. High levels of government debt can have adverse effect on the economy, including crowding out private sector investment, creating the expectation of future tax increases, and injecting overall uncertainty into the economy. It is critical that Singa does not represent a material shift from the government's long-held policy stance of maintaining fiscal prudence. We must ensure that our net asset position remains strong to absorb the borrowings under Singa. The debt we accumulate must not put unfair pressure on future generations. So to avoid the temptation of a spend, spend, spend mentality that access to easy money can engender, it is critical that the government puts in place the necessary safeguards. It is important that we establish a set of robust parameters at the starting line. Now, borrowings must be carefully calibrated, and we must draw a red line that should never be crossed. Mr. Speaker, I'm therefore comforted that clear provisions are provided in the bill to separate major infrastructure from routine infrastructure and recurrent spending. Projects under Singa need to be at least 4 billion, with the infrastructure available for use for at least 50 years, owned by the government and important to national interests. I call on the government to put in place a Singa evaluation panel to include independent expert panels to ensure all projects funded under Singa are highly selective, robustly assessed against the qualifying criteria provided under the bill. There should be also cost-benefit analysis to justify the expenditure. It is important that our borrowings are sustainable and prudent. The bill includes safeguards that cap the overall gross borrowing at $90 billion. However, statutory boards such as HDB, LTA, PUB have also issued bonds on financial markets to finance infrastructure projects. How do we ensure that the cumulative bond issuance, whether for Singa or non-Singa projects, by all government agencies as well as contingent liabilities, remain within acceptable range? Borrowings under Singa are capped at 90 billion, about 20% of today's GDP. I would like to ask the Minister, will this limit be adjusted as GDP grows. How will the government ensure Singapore's AAA credit rating be preserved amidst increased borrowings? Sir, the bill provides for an annual interest threshold of 5 billion to avoid imposing burdensome financial costs on future generations. Nevertheless, the potential interest cost of $5 billion on our annual budget is still very significant. To put things into perspective, the impending GST hike of 2 percentage points is expected to raise $3 billion in revenue. But GST would have to be raised by 3.3% to cover interest costs of $5 billion. This does not include the additional revenue needed to also fund annual depreciation of the capital expenditure borrowed under SINGA. Of course, having said this, given the current low interest rate environment in the foreseeable future, I do agree with Honourable Member Liang Yinghua that it makes sense to tap the debt market now. But we must remember interest rate will rise, can rise. So this bill does provide some buffer for interest rate cycles use and the potential for issuance of longer tenure bonds. Mr. Speaker, the government's intention to issue green bonds under SINGA is a great move. For a start, up to 19 billion in public sector green projects have been identified to be financed by green bonds, including the waste and water treatment facility at Tuas Nexus. SINGA has the potential to catalyze the flow of capital towards sustainable development, not just in Singapore, but in Asia. I have seen a strong momentum amongst investors around the world towards environmental, social, and governance ESG causes, with increasing numbers of asset owners making commitments to prioritize sustainability and investing for good in their investment portfolio. Therefore, the green bonds under SINGA are therefore likely to be well supported by market demand, attract more favorable pricing, and have potential to deepen market liquidity for green bonds. Last but not least, I would like to end by seeking a number of clarifications from the Minister in relation to the assets under SINGA. With the expectation that the infrastructure should be available for use for at least 50 years, does 90 billion limit takes into account upgrading and maintenance costs over the lifespan of the infrastructure? If not, where in the budget does it provide for this cost? 2, if interest rate rise and the cost of debt servicing hit the threshold, does the government have the right to divest the government-owned assets in part or fully to keep within the interest rate threshold? The government can raise money outside of Singapore and in a currency other than Sing dollars. How does the government intend to manage the foreign exchange risk related to this borrowing?
Associate Professor James Lim.
Mr. Deputy Speaker, during the Budget 2021 and subsequent Committee of Supply debates, I had suggested that our notion of infrastructure should not be limited to traditional understandings of physical structures and facilities. I explained how, if we wish to be a leader in the modern, knowledge-driven economy of the future, we can and should direct our development expenditures ever more toward investments that are essentially weightless in nature, and scale back on the lumbering, massive capital projects of yesteryear. Today, I wish to flesh out these arguments in greater detail. I will explain how investments in human capital are not only distinct from investments in labor, but also more akin to our usual definitions of infrastructure. I will also share how returns to human capital often significantly exceed those of hard infrastructure, even as we are looking purely at the boost to macroeconomic growth. I then offer a simple checklist of how we can distinguish between human capital investments from recurrent expenditures. For starters, allow me, again, to applaud the Ministry for its willingness to relax its traditional reticence toward borrowing, to recognize that this really is an opportune time to exploit historically low interest rates to finance important, long-term investment opportunities. I sincerely believe that there is a pearl of wisdom in this oyster of insight. I do have a number of concerns specific to the bill itself. My first concern has to do with both the total borrowing limits of 90 billion as well as the interest threshold amount of 5.5 billion stated in Clause 5 of the Act. While I understand that it is ultimately necessary to impose specific thresholds, I think it's worth asking how these values were arrived at. I also wonder why the interest threshold of 5 billion was chosen, which would imply an interest rate of 5.6%, as Minister Heng alluded to, because this strikes me as rather high given the current interest rate environment. And since rates are locked in at the time of issuance, it also raises the hurdle rate for infrastructure investments that may be considered. Second, I note that Clause 5 of the Act also allows for monies to be raised in foreign currency. As Member Fumiha has mentioned, this suggests that if our inherent liabilities are long-term and denominated in Singapore dollars, this exposure, if undertaken in foreign currency, subjects the debt to a non-trivial amount of currency risk. What mitigation mechanisms does the Ministry or MAS plan to deploy to limit such risks? Third, Clause 11.2 of the Act defines nationally significant infrastructure to be one that has a useful life of at least 50 years upon completion of the project. Again, while I appreciate that a duration for what constitutes significant would ultimately have to be chosen, I would note that many existing infrastructure projects would not have qualified under this rather long time span. The Tanjong Pagar Container Terminal, for instance, began operations in 1972 and moved to Pasir Panjang in 2017, amounting to 46 years. The Brani Terminal dates back to 1992 and is set to be decommissioned in 2027, by which it will have operated for 36 years. Kallang Airport lasted for 19 years, and Paya Lebar Air Base, while it operated as Singapore International Airport, lasted 28. A lower useful life threshold of, say, 35 years strikes me as more reasonable. Finally, I would add that Clause 11.4 requires that the qualifying capital expenditure for every project participant must amount to at least 4 billion. For public-private partnership projects, then, this would either rule out those where the government is either unable to secure sufficient private sector buy-in, which may in and of itself be a signal of the project's potential viability, or when buy-in is sufficiently large, it would preclude the government from being able to take a minority stake. I understand that this is the purpose, but nevertheless, it should be clear what our trade-offs are. Now, having said all that, what is infrastructure? The Oxford English Dictionary defines it as the basic systems and facilities needed for the operation of a society or enterprise. Such systems and facilities could, and typically do, refer to roads, bridges, power, ports, or what I will refer to as hard infrastructure. Roads get us to work, power keeps us working, and ports allow us to sell the fruits of our work to markets far and wide. There's no dispute that when designed and implemented well, hard infrastructure, accumulated over the span of many years or decades, can yield valuable payoffs to an economy and society, and hence is an endeavor worthy of government investment. But it is not difficult to conceive of other systems that are critical for the successful functioning of any modern economy. We sit in a house operating under the auspices of a particularly successful realization of the Westminster system of government, without which our contracts might not be honored, our policies not delivered, or our peace not guaranteed. Our healthcare system has kept us safe from the ravages of COVID-19, and our educational system has allowed our emergence, in the words of founding father Lee Kuan Yew, from third world to first. These latter two aspects, health and education, unarguably constitute systems that enable the operation of not just our, but any 21st century economy. We often refer to the accumulation of knowledge and wellness which makes us productive as human capital, and the systems that deliver human capital are essentially soft infrastructure. Mr. Deputy Speaker, I am not alone in insisting that infrastructure can be more broadly and meaningfully defined. The recently announced American Jobs Plan, while billed as a $2 trillion infrastructure stimulus, nevertheless construes a much wider scope for what constitutes infrastructure, including the sort of soft infrastructure components I am suggesting here. Now, if one is willing to apply a charitable interpretation, Clause 2 of the bill actually already allows for Singa to encompass soft infrastructure. Part B7 states that investments are to support or materially improve productivity, and Part C requires that they benefit present and future generations of Singaporeans. Human capital investments are entirely consistent with both of these subclauses. The only limitation being that it constrains infrastructure to any structure or building, whereas I would instead allow for structure, building, or project instead. Now, the standard concern that this government has historically raised is that we should not be financing routine spending, the payment of our education and healthcare professionals, or funding allocated to subsidize such efforts with long-term borrowing. But these are only recurrent expenditures when viewed from the perspective of the service delivery providers. In this sense, paying our teachers and our trainers, our doctors and nurses, our scientists and researchers are certainly a variable cost. But when viewed from the perspective of the recipients, our students, our temporarily sick, our potential inventors, we can see how we are ultimately vesting value into the future. Moreover, we already systematically embed development expenditures, which by definition are deigned to be long-lasting, into our annual fiscal budgets, a recognition that is of what is spent on a year-to-year basis cannot be easily disentangled from multi-year projects. By the same token, funds devoted to soft infrastructure can and should be regarded as non-recurrent development financing, especially when returns are expected to accrue over the very long run. My Sengkang colleague, Louis Chua, will elaborate on why this distinction between development expenditures and long-term assets may well turn out to be an artificial construct. Another objection to government investment in human capital, or soft infrastructure more generally, is that being embedded in private individuals, investing the greatest benefits to them directly, could mean that it's difficult to justify paying for skill and experience acquisition out of the public purse. However, there are means by which such private returns may be recovered. One approach is to offer scholarships that are contingent on incomes finally earned. I will return to this example in a bit. When we think about investments, the standard approach is to compare observed returns. This is bread and butter work for the professionals, fund management industry, of which I have been a part. As an asset class, the expected long-term returns from global infrastructure, net of inflation, is only 2.6%. In contrast, the real returns to an additional year of schooling is often in the order of 10.2%, almost 10 times as large. One could argue, of course, that such returns are private returns and do not capture the contributions of each of these factors in macroeconomic performance. That's fair enough. So let's go ahead and compare their respective contributions to economic growth. While estimates may differ, one recent study suggests that a 1% increase in infrastructure capital can elevate output by 7 to 10%. Not a number to be sniffed at, but the comparable increase in secondary education alone could induce gains of 10 to 12%. Other credible estimates suggest even higher gains, as much as 16%. So the bottom line is straightforward. Whether we focus on public or private returns, investments in soft infrastructure, such as human capital, generally offer a higher payoff compared to hard infrastructure. And my belief is that we should invest more in the type of infrastructure assets that offer a greater bang for the buck. Now, while a comprehensive checklist for evaluating the merits of any human capital project falls well beyond the scope of this speech, I will sketch out some assessment criteria that I believe are worth considering as to whether a project should be classified as soft infrastructure. First, as a basic principle, the assessed returns from the project should more than pay for its original outlays. This is a remarkably low hurdle. Schooling projects that permanently raise an individual's income, say a full-ride scholarship to university, could translate into as much as 70% higher lifetime earnings. Such higher incomes would mean higher tax returns over the course of the person's working life, which could easily pay for the original costs of the scholarship. Most capital projects often impose static criteria involving cash flow analysis. The most common among these are payback period computations, which is the time needed for the project to return the original investment in terms of cash flows generated. For hard infrastructure, these may be measured in terms of tolls or user fees. For soft infrastructure, these would be evaluated by enhanced tax revenue. Since changes in taxable incomes are not generally large, we can conceivably entertain payback periods of between 10 and 12 years. Third, capital projects also allow for dynamic criteria, such as the net present value of a project or its internal rate of return. Such criteria are easily adjusted to accommodate human capital projects. The main adaptation is to substitute the useful working life of a project with the average duration of a working life. In advanced economies, this duration averages 36 years. This itself would exceed the useful life threshold of 35 years that I outlined earlier for hard infrastructure projects. Finally, as is the case for hard infrastructure, all borrowing should roll in the full amount of the project's expenditure, including interest costs, and regardless of whether the disbursement is over time, into the initial borrowing issuance. This protects against unexpected changes in interest rates and the need to roll over borrowing. Now, what might some examples of soft infrastructure projects, which broadly meet the conditions I set out above, be? In my earlier speeches, I spoke about how we could finance smaller class sizes, even if on a limited basis for languages and math, or to provide additional funding for teaching aids. This will allow us to avoid closing or merging schools and instead direct Singa funds toward keeping schools open, albeit with trimmed down class sizes. Similarly, we could use Singa to seed an initial insurance risk pool so as to enable us to roll out redundancy insurance without delay and without drawing down on our reserves. The Workers' Party manifesto has also suggested raising the targeted percentage of university graduates per cohort, expanding additional baseline funding for less popular schools, and expanding the number of infant care centers, especially in demographically consistent neighborhoods. All these examples could conceivably qualify as long-term human capital accumulation projects. Two more ideas may be considered. First, we could use Singa to seed a fund for income contingent scholarships, as I mentioned earlier. The government pays for all the costs of university or a continuing education program, perhaps subject to a very modest co-payment as collateral. The recipient would then pay off the acquired debt only in the event that they secure a job following graduation. Of course, some details, such as the specific major that is allowed to be undertaken, may need to be finessed. But the overall idea strikes me as eminently implementable. Second, we could direct Singa funds toward vouchers that would be applied by parents to send their children to both non-KIFAS eligible preschools as well as charter schools, which are schools allowed to develop non-traditional syllabi that de-emphasize academic testing, but nevertheless set rigorous, accessible markers for inquiry, innovation, imagination, and invention. The key difference here is that these schools would be funded indirectly by the vouchers instead of direct Ministry of Education approved funding. The upshot of such schools is that they may even generate excellent test scores, even if this objective does not feature in their original mandates. Mr. Deputy Speaker, I have thus far emphasized all the economic payoffs to investing in soft infrastructure. In closing, allow me to also touch on why the benefits of human capital accumulation go far beyond simply improving the productive capacity of our economy. A nation rich in human capital is often one that is simultaneously rich in ideas and experiences, happiness and well-being, wisdom and understanding. These contribute far beyond the narrow scope of economics. An educated and informed populace will be engaged, creative participants in our political process, enhancing our democratic credibility. Creative and curious individuals also bring out diversity and novelty to our social environment, enriching our cultural and artistic landscape. Indeed, Gary Becker, the Nobel Prize-winning economist who pioneered much of the early work on human capital, deeply understood the importance of habits, culture, and social interactions, and the role they played in the long-run success of a nation. It is in this spirit, extending beyond only dollars and cents, that I'm making the case for us to expand our conceptualization of Singa infrastructure beyond structures and buildings to encompass investment in our children, in our people, in the one resource that we truly have as a country. On that note, Mr. Deputy Speaker, I offer my support for the bill.
Order. I propose to take a break now. I suspend the sitting and will take the chair at 5:15 p.m. Order, order.